Thank you. At this time, I open public comment. Public comment will be limited to 1 minute per speaker, keeping in the same tone as the previous meetings. Our first speaker this morning is Michael Savard.
May I make an objection to the proceeding before the first word stated by public comment? Do you mind?
Sure. If you'll please hold, Mr. Savard.
Sure.
Yes,
Thank
sir.
you. Thank you. Respondent objects and renews her continuing due process objection that members of this tribunal, including council members Hernandez and Campos, are material witnesses with personal knowledge of disputed adjudicative fact.
Any opposed, say nay. Nay. Motion carries. Thank you. Mr. Savard.
Thank you. Malfeasance, incompetence. These are all words you're using to carry on this charade. I wish I had more than a minute. You've taken away at least the 3 minutes that I would have liked, because I can't say everything that our mayor has done for this city in 1 minute. However, we must realize, the Federation of City Mayors, 14,000 strong, recognizes her. Our police department, our firefighters recognize her and support her. And most importantly, the people of Corpus Christi support her. They've elected her 3 times in a row, more than any one of you. And it will be 4 times in a row unless you can carry out this ridiculous situation you're doing. The mayor is what we want. I've talked to 2 of you over the past couple of months about different subjects, and never once did you ask me what I thought. As a professional marketing person, I like to do my own personal surveys. I have talked to many people in Corpus Christi.
Thank you, Mr. Savard.
And they all want the mayor. Let the people decide.
Thank you, Mr. Savard. Sean Merritt.
Sean Merritt, Corpus Christi citizen. How we all doing today? What we have, I'd like to just share, if I could. Doug Allison did a great job showing things. I would like to add, in the 2 years I've been here, there are First Amendment and public conduct violations, content-based suppression of speech, selective enforcement of decorum rules, premature termination of public speakers, using disruption as a basis to silence protected speech, targeting specific individuals differently than other speakers, selective enforcement based on audience reaction, censorship based on profanity rather than actual disruption, suppression of constitutionally protected political speech, requiring or overreaching in personal information requirements beyond what is necessary for public comment. And also, this individual, through her political consultants, goes after her political opponents. And I think you all know this just as well as I do. So that is the character of this lady here. That is the mayor we have. Thank you for my time.
Mr. Merritt. Shelley Hinojosa.
Good morning, Mayor and members of the City Council. My name is Shelley Hinojosa, and I'm here because I believe the will of the people should be respected. Our mayor was elected by the citizens of this city, and the decision belongs to the voters, not to council. If the citizens decide they want different leadership, they will have that opportunity at the ballot box. That is how democracy is supposed to work. I ask each of you to honor the voters, respect the voting process, and allow the people, not politics, to decide who serves as mayor. Thank you.
Thank you, Ms. Hinojosa. Melinda de los Santos.
Good morning, Melinda de los Santos, District 2. Again, I want to thank Mr. David for bringing this matter to the attention of Mr. Zanoni and Rachel for her pursuit and for transparency. Evidence and depositions strongly indicate that Mr. Ramirez altered the screenshot to remove dates. In my humble opinion, I don't think he needs to be put on probation or something and not do any business with him for a while. But once brought to the attention of the mayor and city council, which evidence did support this, that they knew about it, then what we have to decide, or you have to decide, was there misconduct, malfeasance, incompetence, or willful neglect in order to get this approved through the second reading? And it appears the change of the documentation from the, going from a FEMA requirement to, some patio, whatever, I think there was a change. So please consider all the evidence. Thank you.
Thank you. And Ms. Rebecca Huerta, do you have any other public comments?
No, ma'am, we do not.
Okay, then we'll close that section at this time, and I will ask for both parties to reannounce themselves. If you could hit your microphones. Thank you.
Douglas Allison, appearing for petitioners.
Thank you.
John Flood, appearing for respondent, Mayor Paulette Guajardo.
Thank you. At this time, the mayor will take seat at the witness table again.
I have no questions. The witness was passed, and I have no questions for the witness.
Okay. All right. Thank you then. Then do the petitioners wish to offer any exhibits at this time?
We do. We have some additional exhibits to offer. We would offer exhibit number 53 on the strength of the affidavit, but it's going to be modified. That is the February 27, 2024 agenda packet for that date. In other words, it's city documents, and we're modifying it because we had previously included everything on the agenda, and there was the objection that was too long, so we, by agreement, or I shouldn't say by agreement, we have agreed, and we have limited it to only the portion of the agenda packet that related to this item. So we'd offer that at this time.
And the number was 57?
53.
I'm sorry, 53. I have not seen the revised 53, and so at this point, I don't know exactly how to respond. I will take council's representation that it's simply a pared-down exhibit, and if it's okay with the tribunal, what I would prefer to do is after I review it, if that's okay, then levy any objections I have to that particular exhibit. I would incorporate any prior objections I made to it, subject to that.
So long as I can rest subject to, I don't have a problem with that.
And I don't have a problem with that either.
Okay, thank you. Yes, sir.
We'd also offer Exhibit 73, which is the company agreement of Elevate QOF.
Are we not going to go through, my understanding is that there were several exhibits offered by virtue of an affidavit that was filed a couple days ago, long after this tribunal's deadline. Are we not going to go through all of those, or are we going to just go through?
I'll make the offer in toto.
So the offer, okay.
So let me do that. We'd offer exhibit number 73, which is the company agreement of Elevate QOF. We would offer exhibit number 80, which is the deed transferring title to the subject property, and 81, which is a related deed for the subject property. So that's 80 and 81. We would offer exhibits number 82, which is the February 20th, 2024 website for the city as it exists today. I'll inform the tribunal that's a function of this group voted to restore certain documents to it. And so this exhibit shows that website as it exists today, okay? And then exhibit number 84, which shows the April 23, 2024 city website as it exists today. And then we would offer exhibit number 86, which is a copy of sections 10 through 18 of the city charter. And then and then exhibit number 87, which are the signed oaths by the mayor. And then exhibit 88, which is the CCREDC confidentiality agreement signed by the mayor. We would offer those exhibits at this time.
I have a general objection to all of those exhibits because they were tendered after the deadline set by this tribunal, and so I would make an objection to that and ask that that objection be ruled upon.
Do we have a direction from this council? Mr. Flood, would you like to respond to that?
Sure. Yeah, generally, I understand that certain any trial of a matter, there are exhibits put on an exhibit list. I actually published all of my exhibits in the time frame that was suggested. I don't think it was an order that was suggested by this group. All of their exhibits were published after that deadline, okay? And always in the course of a proceeding, there are new exhibits that maybe you didn't anticipate and are allowed either for because they weren't anticipated or because for rebuttal purposes. And so it is very, very typical during trial that additional exhibits get added to the exhibit list. We've been doing it and they have been doing it. There's nothing just to say they're later than I wish they were, when quite frankly, all of them, except we did not at the time have the oaths of office or the CCREDC confidentiality statement back earlier in time. All of the other ones that are being offered are items that have been in their possession at least since May of 2026. And so on the strength of the affidavit and complying with, I think, the rules that this group has adopted, we think that they are in proper form and should be admitted. We ask that there be a motion to overrule the objection.
Thank you, Mr. Allison.
Respondent stands on her objection, her timeliness objection.
Councilman Hernandez.
Yeah, it seems to me that a lot of these things were brought up during testimony at the last.
Mr. Flood, do you have any other objections to these exhibits?
Absolutely. I have several. That's why I stated that this is a global objection to these late exhibits. And so I have filed with the city secretary a couple days ago, shared with council our objections to all of the new exhibits. My understanding is council is now offering a pared down set, and so I have specific objections to the ones he just specified on the record also. So this is a general objection to the timeliness of the provision.
We would request that all their objections be made, which I think is the customary way to address that.
I am going to ask that all of my objections that I filed 2 days ago be addressed by the tribunal.
Could you list those at this time?
Sure. What I would like to do, if it's okay, is address the exhibits that council just specifically addressed,
Yeah.
and then go through my objections that I filed, if that's permissible.
Thank you, yes.
Petitioners have offered Exhibit 73, which is the Elevate Company Agreement. That is objection number 7 on my global objections that I filed a couple days ago. The Elevate Company Agreement is not relevant to any fact issue raised by the articles of impeachment, and I'd ask that the Exhibit 73 not be admitted on that basis.
I'm going to stay with my request that he state all of his objections.
Well, I do, then I'm going to have to get some sort of ruling on my objection number 7 that I filed. And the exhibit has been specifically offered, and I leveled an objection to it 2 days ago, and I'm renewing that objection.
Mr. Flood, do you have any other objections to Exhibit 73?
It is not, no, it is not relevant to any fact issue raised by the articles of impeachment, and so I object to it on that basis.
Do we have a motion to overrule the objections on 73?
For the record, that would be objection number 7 that I leveled.
Thank you for that correction. We have a motion to overrule. Do we have a second? We're presiding over the objections listed to 73, and I have a motion to overrule the objections.
73. No. Right?
No, it's just 73.
Just 73.
Yes, we're going to go through the list individually. Second, all in favor, say aye. Aye. Any opposed, say nay. All right, this objection's been overruled.
Thank you. Objection 15 relates to Exhibits 80 and 81, which are the deeds that were referred to earlier. Those are hearsay and not relevant, and they do not tend to prove or disprove any element of the articles of impeachment. And so I object to the admission of Exhibits 80 and 81 for that purpose, for that reason.
At this time, in the interest of moving us along, those will become more relevant with a rebuttal witness that I've already identified to opposing counsel. We'll withdraw the offer at this point in time so we can move forward. I'll offer them at a later time.
Thank you.
Respondent objects to petitioners 86, which is the city charter provisions, because they are not relevant and they do not tend to prove or disprove any element of the articles of impeachment. I ask that that objection be sustained to Exhibit 86.
I think it's almost like asking for a court to take judicial notice of its own rules. Those are the rules that govern you, and those are the rules that are relevant to these proceedings, so we'd all ask that they be admitted.
We have a motion and a second to overrule the objection. All in favor, say aye. Aye. Any opposed, nay?
Exhibit 88 is the EDC Code of Ethics and Confidentiality Statement. It is hearsay and not relevant, and respondent objects on those basis.
Now, I think it's an exception to the hearsay rule in that it is this tribunal's own records and was provided by the city secretary. No, this one was provided actually by John Flood, which is CCR-EDC.
No, I did not provide that document. That's not true.
John Flood, John Bell, sorry. Thank you.
Who's not here, the document is hearsay. It's not relevant.
Mr. Allison, if you'll complete your...
I apologize.
It's okay. We would offer it at this time on the strength of the affidavit that it is exactly in compliance with your rules that you all adopted for evidence, which it is the type of thing that you all or persons would ordinarily rely on, is an official document like this from your own CC or EDC. So we'd offer it at this time.
Motion and a second to overrule. All in favor, say aye. Aye. Any opposed, say nay. Motion carries.
There, Exhibits 82 and 84 are the meeting details as they exist today, which is not relevant to any fact issue raised by the articles of impeachment. So I would object on that basis to 82 and 84. And request a ruling on that objection, please.
Yes.
And in response to that, it's directly relevant because one of these impeachment articles has to do with the improper removal of things from the website, of information from the website, and changing the public record, which is a violation of law. It's unlawful. And so to be able to see what it had on February 20th and then what it has now and how that's been changed and was altered, and to use that in conjunction with, you may remember it's already an admitted exhibit, Legistar, that says when everything was removed and when things were put back. And so it goes directly to that article of impeachment and therefore is relevant, and we'd ask it be admitted, that those two be admitted.
I'm sorry, is 82 and 84, is that in your memo, sir? It is, okay.
Oh, well, no, it's.
No, and Mr. Flood's, was that an objection? I don't see it on your list.
I'm making that objection.
Now.
Correct. That is not part of the written objections that I filed. I'm making that objection on the record right now.
All right, thank you.
Okay. Does this council have a motion? Motion to overrule. Motion and second to overrule. All in favor say aye. Aye. Any opposed say nay. Motion carries.
I made I made objections to all the petitioner's exhibits. It's my understanding that the new exhibits, which are petitioner's exhibits 70 through 93, have been offered for admission, and I'd like to make objections to all of those, assuming they are all being offered with the exception of the one that is being pared down. I assume they're all being offered at this time?
Mr. Allison?
Yeah, they're not all being offered at this time. I will say that 89 through 93 are the videos that have already been played and are already in evidence. They're not being re-offered different than how they've already been viewed by this group. I just put them in there so that everybody could have copies of it to complete the record, but I don't need them separately admitted, so I'm not offering them at this time. And I also am not offering any of the other ones at this time that I did not specifically articulate.
Okay, thank you.
I will reserve the right to assert all the objections that I made. I would ask for a specific ruling to the extent the objection number 2 is to the extent petitioner's new exhibits and affidavit or other evidence contain, reference, rely upon, summarize, or incorporate any portion of the previously objected to deposition testimony. Respondents' prior objections are expressly reasserted and ask that they be sustained at this time.
Yeah. And I think since we're kind of back to global, I probably should say this, just to be very clear in terms of what's being admitted right now or offered for admission right now. Exhibit number 53, we've agreed that I'll withdraw the offer at this moment because we're going to do what lawyers would call housekeeping, and that is it's a long exhibit about the February 27th meeting, and we're going to limit that just to the items relating to this agenda item so that it'll be a shorter exhibit. And we're going to offer it at a later time, even if it's after I rest. So we don't need any further rulings on that, with that understood. We do have exhibits 69 being offered, 70 being offered, 73 being offered. I have said that I'm going to not offer at this time 80 and 81 because they'll come up with a witness later for rebuttal. But I am offering at this time 82, 84, 86, 7, and 88. And this group having overruled specific objections, which has now happened, we'd ask that those that I've now, I hope, very clearly articulated for the record be admitted.
Mr. Flood.
69 is no objection.
Will that be admitted?
Yes.
I'm doing that for the record.
Yes, sir. We'll let Mr. Flood go through.
Okay.
Thank you.
No objection to 69. 70 is the notice of default letter from City to Elevate QOF. That is the subject of my objection number 5. First of all, I do request, earlier I made my objection number 2, and I do ask that, and if I have to restate it, I'll restate it, but I do request that a ruling on my objection number 2 that I filed 2 days ago. It's on the second page of my objections. And I request, do I need to restate that? Because I want to request.
If you would.
Okay, thank you. To the extent petitioner's new exhibits and affidavits or other evidence contain, reference, rely upon, summarize, or incorporate any portion of the previously objected to deposition testimony, respondents' prior objections are expressly reasserted. And so I'd ask for a ruling on that objection, please.
I would ask, I think he's going to state all his objections. I interrupted a moment ago, so if we can let him state all his objections, or would you like a specific response?
I specifically request a ruling on that objection.
Do we have a motion to overrule the specific objection? Motion, and do we have a second? Second. All in favor to overrule, say aye. Aye. Any opposed, say nay. Nay. Thank you.
Objection 5, I leveled to Petitioner's Exhibit 70. That is the default letter. It's not relevant to any fact issue raised by the articles of impeachment, and I'd ask that that objection be sustained and Exhibit 70 not be admitted.
And it is specifically relevant. Our response is it is specifically relevant because it actually is an official document of this body. 2, whereas they're continuing to suggests that somehow the mayor had no knowledge, and that even back at the time that the representations, I think it's their case, that were true and correct. I mean, that document, I think, addresses very specific information that is germane to these proceedings about the misleading nature of the representations made to the Type B board when made. So it's directly on point to some of the issues that have already been allowed into evidence. Thank you.
Motion to overrule.
We have a motion to overrule. Do we have a second? Second. All in favor say aye. Aye. All opposed say nay.
The next, I believe the next one that was offered is the Exhibit 73, which is my specific objection number 7. That is the Elevate Company Agreement. Respondent objects to petitioners.
Mr. Flood, I believe that we've already determined on these objections.
I'm only bringing it up because council offered it just a moment ago, again, put it on his list, and so I thought maybe it hadn't been admitted, so, okay, all right, thank you. There was also a reference.
The one that, I'm sorry, the one
That's-
that hadn't been addressed was 87, Exhibit 87.
That is the, oaths of office. Yeah, we have no objection to the oaths of office of the mayor being admitted in this. Thank you.
Do we have a motion to admit Exhibit 87? Motion and a second. All in favor say aye. Aye. Any opposed, nay. Motion carries.
If I am, if our objections to Exhibit 88, which is the EDC document, those were already addressed. Council
Yes,
brought it up again, but I think those have already been addressed.
thank you.
So I do want to go through my general objections and get those ruled upon. Objection number 1 was.
Mr. Flood, just a moment. If you could clarify which exhibits you are referencing precisely, because we just went through the list that have been admitted.
These objections are to the body of exhibits that are contained within numbers 70 through 93. And so the first objection that I made on objection number 1 were to the admission of the deposition testimony of Peter Zanoni, Heather Hurlbert, Philip Ramirez, Mike Culbertson, Alan Wilson, and Sonny Parnell. That objection was based on the offer of the deposition clips that were played, and so I believe council has withdrawn those exhibits at this time, and so that objection does not need to be ruled on. Objection number 3 is petitioner's objection to the affidavit in support, because it's not proper to use an affidavit as a means to circumvent the rules of this court or the rules of evidence and transform otherwise inadmissible evidence into admissible evidence. The affidavit is defective, and accordingly respondent objects to the affidavit and all the evidence offered through or supported by the affidavit. And I request a specific ruling on that objection, please.
Mr. Allison.
Sure. The rules that were adopted, candidly, it sounds like his objection is one that he's wanting to make under different rules. The rules that this group adopted in terms of admission of evidence were very specific with regard to allowing deposition testimony, with regard to allowing documentary evidence, with regard to excluding some types of evidence as hearsay unless it met the burden in this group's opinion or vote, majority vote. Even hearsay then is admissible if it's the type of document that you would normally rely upon, and a lot of that has to do with the emails back and forth between city employees and CCR EDC and all of the things that have been admitted. And so the point is that he's making an objection that I don't think even applies given the rules that have been adopted by this tribunal, that all of the offered exhibits with the affidavit that I've provided, and specifically the rules you adopted said the way to get exhibits in is provide the affidavit verifying that they are what they are, basically. And then if it's the sort of document that you think is trustworthy or that you normally rely on or that the public would normally rely on, like sworn testimony, then it becomes admissible. So we'd ask that that specific objection be overruled.
Motion to overrule.
We have a motion and a second. All in favor say aye. Aye. Any opposed say nay.
And that was objection number 3 we just went over?
Yes.
Okay. Objection number 4 is respondent objects to all the petitioner's new exhibits because they're replete with inadmissible hearsay and hearsay within hearsay in violation of Texas Rules of Evidence 801, 802, and 805, which this tribunal has specifically adopted. Rather than presenting testimony from witnesses with personal knowledge, petitioners repeatedly attempt to establish facts through layers of out-of-court statements. My objection goes through that list. And so I would ask that objection number 4 be sustained.
Mr. Allison.
Yeah, and obviously, really, to be honest, if I can shorten this, the response I gave a moment ago is the same response as I give now, so I adopt it. And what he's trying to exclude, I guess, just globally is the emails between city staff, the testimony under oath, all the things. I mean, it's just a general objection and really kind of a subset of what he argued just a moment ago. So we'd ask that that objection be overruled.
Overrule.
We have a motion to overrule. Do we have a second? Second. All in favor say aye. Aye.
Objection, petitioners exhibits 74, 75, 77, and 78. Those are those appellate court filings in the David versus City case. Are those being offered at this?
I haven't offered them.
Okay.
They haven't been offered. Thank you.
71 and 72 are the Secretary of State formation filings. Are those being offered at this time?
71 and 72 have not been offered at this time.
76, is that being offered at this time?
No.
70, let's see.
It's Mark Scott's.
Are Exhibit 79 being offered at this time? That is the public information reports on the different entities.
Not at this time.
That concludes this point of respondents' objections to the new exhibits offered by petitioner during trial.
Okay. At this time, Mr. Allison, do you have any other exhibits you wish to offer?
Not at this time. I've put in the record the long list of what I think what I know I'm requesting specifically be admitted. Their objections having been overruled, I just think we need to probably hear the magic words admitted, but I'll let you.
Does he have any other,
Before, well, that's okay.
One moment, Mr.
any
Flood.
other witnesses he's going to call?
Do you have any other witnesses you're going to call, Mr. Allison, at this time?
Not at this time. As indicated, I have a rebuttal, but no further witnesses at this time.
Does he have any exhibits?
Mr. Flood, do you have any exhibits you wish to offer at this time?
We have served our amended our ones we just filed. Yes, petitioner has, respondent has offered Exhibit 48 through 63 and have submitted an affidavit in support and would request the admission of respondents 48 through 63.
Mr. Allison.
Since I told you earlier that we allow exhibits even though they're amended exhibits or on the amended exhibit list, and even though they're filed after the deadline, and he did all of those things, we don't have objection because those would customarily be admissible.
Thank you, Mr. Allison. Do we have a motion to admit the exhibit? Motion and a second. All in favor say aye. Aye. Any opposed, nay. Exhibits have been admitted. Do you have anything further, Mr. Flood, to admit?
It's petitioner's case in chief still. I do have a motion to quash that I would ask the tribunal to consider.
Before we go to that, I do think I need a motion to admit on the ones where the objections have been overruled, unless you think those have already been admitted.
We would have to, respectfully, I think I'd have to re-argue
No, no,
every
I-
one of my
No,
objections.
just, subject to your
They've been
objections.
admitted.
Pardon?
They've been admitted.
I want to make sure. Thank you.
Yes, thank you.
Okay. We lawyers always like to hear those magic words. I apologize.
Mr. Flood, did I hear a motion?
Yes, I have a motion to quash that was filed, that my client filed related to an unauthorized subpoena that she received. And I want to ask the court's ruling on that motion, please.
Mr. Allison, do you have an argument?
It's their motion. They have no argument.
No argument.
The
Do we have, Mr. Flood, if you could clarify the motion, explain what it is for council's understanding.
A subpoena for documents was served on July 8, 2026, upon my client 108 days since the initiation of this impeachment process by the City Council on April 14th. It is Exhibit A to the motion to quash. The subpoena claims to be issued by the City Council and City Charter, but cites no authority for a mid-trial subpoena. The American legal system is broken into two parts, pretrial and trial. Trials are about proving evidence after pretrial investigation. They are not inquisitorial tools. Corpus Christi's charter reads accordingly. Article 2, Section 17 of the charter authorizes the council to compel records and evidence as part of an investigation, which is the title of that chapter. Petitioner specifically requested subpoena power during the pretrial period for the issuance of summons of documents and records. That's Exhibit A to my motion to quash. On June 2nd, this council authorized the petitioners to issue subpoenas, quote, as requested by the parties. As part of the pretrial stage in this matter, the mayor pro tem at that hearing stated, both parties have filed witnesses list and request subpoenas. I move to authorize the attorneys for the petitioners and the mayor to issue subpoenas as requested in their motions. The requesting party will be responsible for service of subpoenas. Any objection from the City Council to this ruling was asked. Then we need a motion and a second. Can I get a motion? There was a second. So moved. All in favor say aye. Any opposed? And the motion carried. The City Council did not unconditionally hand over its subpoena authority to Petitioners' Council. Petitioners were not given City Council's subpoena authority during the trial period, nor is there indication that City Council specifically authorized Exhibit A, which is the subpoena to my clients, the July 28, 2026 subpoena. Accordingly, the July 28, 2026 subpoena was issued without legal authority and should be quashed. Specifically, the subpoena for documents, which was received, was a subpoena asking for invoices for a phone number, for one of my client's phone numbers, asking her to produce invoices showing all calls to and from Peter Zanoni, Heather Hurlbert, Leah Oliveri, Devin Bacta, and Philip Ramirez, and also text messages to and from those same people. And both of those requests for subpoena records were limited to the time frame of August 1, 2023 through May 15, 2024. The subpoena also asked for the same call invoice records for her other phone number. There's two phone numbers that are made the subject of it. And so we filed, the motion to quash is to quash quash the subpoena for the reasons I stated, and I would ask that motion to quash be granted. The effect of the motion to quash would be that my client is not obligated to respond to the subpoena. And that's the motion I ask that the tribunal grant specifically.
Thank you. Mr. Allison?
Yes, thank you. I think all of you having been here, it's very clear why we asked probably for the mayor to produce. She does have 2 different phone numbers that we know of, and probably very clear to you because of phone records we've already discussed with her and with the mayor, and because of text messages we've seen, because we have limited production of phone records in this matter. We only have Devin Bachta's and only Mr. Ramirez's. So because of the testimony, obviously, we issued a subpoena for her to bring her phone records so we can see who called who, when, and how long they talked. We limited to the request to certain people to avoid we're not trying to get into who she called this family, that sort of thing. So we think we've limited it appropriately, which is what we as lawyers try to do, is to be measured in what we ask for. We've asked for it for a limited period of time, the period of time germane to the CCR EDC consideration of the matter, Type B consideration of the matter, and also the City Council's consideration of the matter. So we've limited it in time. My point being, we've limited the people we're asking about, her phone calls to and text messages to, and we've limited it to a specific time frame. That makes it, I think, a very reasonable request. We're not asking for the sun, moon, and the stars. Those are the sort of things we as lawyers, I think, are trained to do, because that is exactly the sort of subpoena that should be performed. I know this tribunal is aware of the testimony with regard to the phone records we do have, and we think, quite frankly, in the name of transparency, that there ought to be, if you're going to be the mayor, if you're going to be a full-time mayor, and if you're going to preach transparency, you should live by transparency. And the fact that they come in here now and tell you, because his argument essentially is, you don't have the authority to ask for them. The city charter, even though it specifically gives subpoena power, and the city charter does not limit that subpoena power to pretrial only and not during trial. And it is customary, it happens all the time, where we issue subpoenas during trial, and we issue them because of testimony received during the proceedings. And so for all of those reasons, the subpoena has been limited in time, limited in scope, applies specifically to a relevant issue in the case about who was called when and where, and text messages exchanged. And because transparency, and because this tribunal's city charter specifically allows the issuance of subpoenas for such matters, we ask that the motion to quash be denied.
Respondent stands on her motion to quash, which she filed days ago, and specifically cites the lack of authority for the subpoena, and so we ask that the motion to quash be granted.
Motion to deny.
We have a motion and a second to deny. All in favor say aye.
Aye.
Aye. Any opposed, nay?
Nay.
Well, then, if I may, I would, now that the motion to quash has been denied on this subpoena, I will tender to the tribunal my affidavit of compliance, my original, which I will tender to the city secretary, and then I have copies for opposing counsel and the council. May I approach?
Yes, sir.
Thank you. Thank you.
You want to give to Shamsi?
He said he doesn't want it. The affidavit of compliance, I have signed this document. It explains our compliance with all reasonable efforts made to comply with the subpoena. And we ask that my affidavit of compliance and its exhibits 1 through 6, that be admitted into the record of this proceeding.
I think he's going to probably need to give it an exhibit number. I'd ask that I be given an opportunity to review it. Just at a first blush, it clearly is not compliance. There aren't any I don't see any cell phone records here.
There's a,
I mean, and so, I mean, selective compliance is not compliance. But we can argue about that later, but I don't think it's time. I think they need to give it an exhibit number, and I'll probably have no objection to it as far as it being an exhibit. But I don't want to pretend like they gave me cell phone records when they didn't.
there's an explanation for the cell phone records. These are what are considered archived records at the provider that we have made, and you'll notice in the exhibit that there are repeated efforts to try and recover these archived records. It's not as simple as getting your last month's bills. It's certainly not. And so there was a good faith effort engaged in by myself with my client. I personally reviewed her phone, and you have those text messages now. There has been a continuing effort, they might even get the email today, about getting access to the call logs. It's not as simple as you might expect, and I cover all of that in my affidavit. You do have now all of the text messages in her possession for both of those phones from all of those people that exist on either of those phones. And you have my affidavit verifying that I did that personally myself, and we went through those, and you now have them all. So there are no written text messages that exist that are within the scope of this, that are within my client's custody and control, that you do not have. You have them all now. And I believe as far as the exhibit number goes, the rules said that they can be marked by the city secretary. So I'm going to let the city secretary tell me what that exhibit number is. Thank you.
Mr. Flood, are you then offering this as an exhibit?
Yes, I am.
Okay.
Well, let me just say, for purposes of the record, I'm not offering it as evidence in my case in chief, nor in his case in chief. I'm simply offering it for the record to show compliance with the subpoena. That is why I'm offering it. It is not to be admitted as necessarily as evidence. It is simply to verify compliance with the subpoena.
Thank you, Mr. Flood.
If he wants to put it into the tribunal's record, we have no problem with that. I do want to point out that he's very clear, and I guess his affidavit will say the same thing. He was very clear in what he just said, that these are what she has in her possession that exist at this time. That means it doesn't include any text messages that have been deleted. That means it does not include any of the bills or invoices that we asked for. And so I have no problem having this tribunal have this document as part of its record. Quite frankly, just by filing it with the city secretary, I think that's already true, okay? And so he's not offering it into evidence, so I'm not sure that any ruling needs to be made at this time, other than it is a part of the record. I mean, I agree with that.
Thank you.
Mayor Pro Tem, just for the record, it would be Exhibit 63. That would be the number. 64, my apologies.
Well, and again, I am not offering it as an exhibit in either respondent's case in chief nor petitioner's case in chief. I'm simply offering it as evidence of compliance with the subpoena that was, in our belief, unauthorized. However, the motion to quash was denied, and so in compliance with that ruling of the tribunal, we provide the affidavit of compliance and its exhibits.
Can't look at them.
Well, then, with that understanding, Ms. City Secretary, if we could regather each of these since they're not being admitted into an exhibit and stored with your records. Thank you.
I just want to make sure that the affidavit and its exhibits are going to be included as part of the record of this proceeding, so that if there's any further proceedings after this, that this is included in this tribunal's proceedings.
Yeah. And I think that's what's already happened. We have a direction to that.
Thank you.
Mr. Flood, do you have any other evidence or items you wish to offer?
During petitioner's case in chief? No, I do not. Oh, well, yes, I do. I apologize. I have 3 very brief deposition excerpts that relate to witnesses that you heard from during petitioner's case. I think it in total is 11 minutes of deposition testimony, and so I would offer those at this time. I do have to get our computer set up, though.
Okay, then we'll recess for 5 minutes and return for those.
Great, thank you. And then I'll have a live witness to follow those. Thank you.
Thank you, Mr. Flood. Okay. Were we able to get the exhibits prepared?
I'm sorry?
Have the exhibits been prepared for the audio and video?
Yes.
They're good?
Yes.
Okay.
Yeah.
We have everyone back.
All of the exhibits that will be addressed with the live witness later on during our case. The next deposition is during petitioner's case. So these depositions, they're being offered during petitioner's case. As far as if the question relates to, and I realize we're not, if the question relates to the later witness, the exhibits that will be gone over with that witness were all just admitted or have been previously admitted.
May I make an announcement? Okay, we're ready?
Thank you. Yes, she's here. Yes.
Yeah, at this time, subject to, we talked about admitting some other documentary evidence later, subject to our right of cross-examination where we elicit additional testimony, and subject to our right to call a rebuttal witness who we have already revealed to opposing counsel. Subject to that additional evidence which we intend to submit, we rest.
Thank you, Mr. Allison. Mr. Flood.
Respondent believed that she was going to be offering these depositions based on representations of counsel during petitioner's case because they are optional completeness offers related to the depositions. And so I would ask that petitioner's case be reopened so I can offer these deposition cuts at this time.
I will ask for a motion to reopen so that Mr. Flood can introduce.
We have
his
no
videos at
objection to
this
that,
time.
if it avoids the motion.
We have a motion and a second to reopen. All in favor, say aye. Aye. Any opposed, nay. The motion carries.
Respondent offers some short deposition clips from Mr. Culbertson, Ms. Hurlbert, and Mr. Zanoni at this time.
And then in this process, we're talking about after you get the application, after it runs through RIMS 2 and the economic development analysis, is there some sort of a staff meeting to say this is a good one, this is a terrible one? How do you handle that?
Between Randy and I, we talk about it and in preparation for presentation to our board.
But I mean,
We have to present all applications to our board.
that's what I was wondering.
Yeah.
Okay, so you're not filtering.
Correct. And in fact, if our board, if we have one that, one of the things we do is when we send it to city, it goes through legal, and legal says if it's eligible for type B. And so it could end there if it's not eligible.
Economic development perspective of what you're looking for. Are there different criteria or guidelines of what type B is looking for?
So under type A, it was pretty simple. It was had to be a manufacturing company, and it had to hit the 12%, at least 12% and 5-year payback. Under type B, there are other things that you can do, so that's how hotels get in. We have gone through the guidelines, and the guidelines are pretty wide open. So because it's allowed under state law. So while the first one was really easy, if manufacturer, we all know what that is. The other ones, start to get.
But is there a written guideline for type B?
Yes.
What do we call that?
The Corpus Christi Type B Corporation Guidelines.
What were your conversations with Heather about changes, about different reasons behind the ask?
Right.
Or whatever the conversation
Yeah,
were.
that due to the questions from the city council and Leah's input that we really needed to change the agenda item. So we did.
Okay, so you first had a conversation, it sounds like, with Leo Olivari,
Yes,
and then you had a conversation with Heather
correct.
at the city?
Yes.
And was it just you and Heather, or who all was at that meeting?
Actually, I think it was an email, just me and Heather.
Did you also do any emails with Leo Olivari?
I don't think so. I think our conversation was on the phone.
You know, probably goes without saying, but I'll let you know. I'm going to guess we're going to get that email. But so do your best to recall what you told Heather in the email. Do you think the email was it prompted by your discussion with Leo Olivari?
I think Leah made the same observation to the city, to Heather, after the first reading.
Okay, but did you call Leah or did Leah call you?
Leah called me.
And she called you for the purpose, it sounds like, of letting you know that the narrative as to the reason for the ask of $2 million needed to be changed.
That's correct.
And you agreed with her.
Yes.
Okay. And the reason it needed to be changed is because of the, whether you will call it a misrepresentation, false, not square, disingenuous, whatever reason you want to put on it, that was the reason for changing it.
No, she said it was because of where it was located. That's why the Type B made their decision. It wasn't based on anything else.
Right. So Leah's point is, hey, we're gonna say it's because of where it's located, and we want a project downtown.
Right.
We don't want to say anymore that it's because of changes, recent changes in FEMA.
Correct.
So you're changing the narrative.
Actually, if you go back to the Type B, that's actually what they said. They said because it was a catalyst for downtown.
Did you ever have anybody ask you to recommend it?
No, not specifically, might please recommend this, no.
Anything along those lines? Don't hedge on me.
No, no.
And in this particular home suites scenario, it was a hotel at the time they were making the ask for $2 million. It was a hotel project that was already in construction.
No. It was, there is a clause in Type B that construction could not have started. I'm not talking about demolition of what was there, but construction could not have started, and we checked with development services, and that was the case.
Okay, so you don't think they had a second story? Built already, framed out?
No, I don't.
It's in demolition phase.
Correct.
Okay, so the project was,
We asked the question of the city, are they in construction? The answer was no.
Is that that finishes the offer of Mr. Culbertson. The next is of Ms. Hurlbert.
is it your recollection also that Peter informed the council during executive session that this slide, this federal instrument or writing, whatever you want to call it, portal screenshot, that it had been tampered or altered?
I want to say that he, and God, I'm trying to remember. I believe that it was, he said there were claims that it had been altered.
Okay. And what else do you remember about that?
I'm trying to remember, that was a long time ago. I don't remember the exact conversation, yeah.
Okay. Are you in any way, and I'm just using the verbiage that's in the recorded statement now, are you in any way refuting that he let them know it had been tampered with?
I think he's, like I said, I think that you said that there were claims that it had been tampered with.
So if for example, do you know if the grant or the award of money that we're here talking about today, do you know, did you ever do anything to test the but-for rule?
Yes.
Who did you talk to about that?
We talked with legal on it on the but-for, because this was not for the construction of the whole hotel. This incentive was given for the development of the retail along the street.
Okay, and then did you,
So again,
did you ever talk to anybody else before, other than legal, about that? About application of the but-for rule?
I believe Mr. Culbertson and I had conversations also.
Anybody else?
I can't recall.
And you just said it, but ultimately you said the money went to improvements on the street.
Exactly. It was for the improvements on the street, which allowed for the development of the retail along the street, which would be consistent with the neighboring retail.
Nothing to do with FEMA.
Well, it had to do with the flood proofing that was needed to be able to achieve that.
You don't recall any specific conversations with them about the, about what would Ramirez and the Homewood Suites Group and Bacta do but for?
So we had conversations that, based off of the requirements that they needed to build to, if we wanted to preserve the retail or have the retail space, that this is what the incentive was for. The but-for came into play in the fact of if they did not receive the incentive, then they would do something different on that bottom floor. So that was the but-for.
And you told me that in the end, though, the only but-for analysis you did was just based upon this improving the curb appeal.
And providing additional retail and restaurant spaces.
Right, so you did not ever go do a model again for the whole project?
No.
Okay. And no one did, right?
No.
So when the change occurred for the second reading, you know what I'm referring to, right?
Yes.
After that change occurred, there was never any sort of modeling of the entire project like had been done at the very beginning when it came out of our EDC. Agreed?
That is correct.
Okay. And you understand that modeling done at our EDC is for the specific purpose. They're given the task of doing that modeling to evaluate whether or not it is an economic development project that qualifies for money.
So yes, they do. Theirs just talks about the return on investment.
That's why they do it,
Over a period of 5 years.
to see if it's worth the investment of public money.
Exactly, but there are other aspects besides just the return on investment that we provide incentives, that we grant incentives for.
And that economic development modeling was never done again once the project purpose changed, right? You just told me that a second ago.
So yes, there was not a financial modeling looking at the return on investment, but I said there are other aspects that are incentivized that is not necessarily a direct dollar for dollar return on investment.
Do you, when it says staff, what department did this project fall under? It falls under EDC and that area, right?
It falls under economic development, yes.
Did you recommend, that's your area, right?
Yes.
Did you recommend it be passed at the second meeting?
Yes.
Okay, so you recommended it even knowing it was the tampering and altering of a federal porthole or whatever?
Yes, because the Type B board based their decision not on necessarily that screenshot, but the merit of the project.
And then a very brief offer of Mr. Zanoni.
Did you in any way, shape, or form consider that just the words coming out of your mouth, I do recommend, that the council would rely on those words and vote yes for it?
For it, the it would be the version 1, the first reading ordinance. I wouldn't recommend it. But if the council's saying, now we're going to do something different, we want this money to be for ground floor activation and whatever else that Leah had said, that one, I would say yes, they could support that, if that's what it was.
Ends respondent's proffer.
Mr. Allison?
Yeah, at this time, subject to the offer of additional documentary evidence which has been expressly reserved, and subject to our right to elicit additional testimony from witnesses called by the respondent, by the mayor, and subject to our right of rebuttal, and we've already identified that witness to opposing counsel. So subject to that additional offers of additional testimony and evidence, we rest.
Thank you. Okay, Mr. Flood, are you ready to proceed?
I am not. There's a live witness that will appear, and so we're going to need to do some logistical maneuvers here.
Okay, so
But I will be after that, yes.
how much time do you need?
5 minutes or so.
All right, we'll recess for 5. Thank you. Ms. Rebecca, are we ready? Okay.
City attorney, couldn't she sit right over here?
Okay, Mr. Flood, if you would like to, please call your first witness. There you go.
Respondent calls Leah Olivery, and I'm very proud of myself for getting that pronunciation correctly right there. May I proceed? Oh, yeah.
Okay, Ms. Rebecca, if you could issue the oath.
Would you like me to stand? I'll go ahead and I'm sorry. Miss Leah Oliveri, I've been saying your name wrong for years, my apologies. Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Ms. Rebecca.
May I proceed?
Yes, sir.
Good morning.
Good morning.
Can you please tell the folks and our court reporter over here your full name, please?
Leah Pagan Olivery.
And are you a resident of Corpus Christi?
I am.
And you received a subpoena in this matter to come and testify today, correct?
I did.
All right. And what do you do for a living?
I'm a semi-retired consultant.
Okay. And you were the Type B board chair at the time of the Homewood Suites incentive when it was processed and approved in 2023 and 2024, true?
I had the honor to have that position.
Okay. And you understand that that's what we're going to talk about today, correct?
I do.
All right. And before calling you as a witness today, you and I met 2 times, correct?
That's correct.
And we met at your lawyer, Mr. Huseman's office, and we reviewed documents relating to the events we're going to talk about today, correct?
We did.
Yes. And those kinds of documents were meeting minutes, agenda packets, emails. I even showed you some videos from council meetings, correct?
You did.
All right. And those meetings were actually this week, Monday and Tuesday of this week?
That's correct.
And you 2 weeks ago when I was here, you came down and because you were there in response to a subpoena, correct?
I did.
Yes. And you and I did have the opportunity to actually meet each other a few months ago. When was that?
I can't remember the time period, but we met because I am a member of the executive committee of a local foundation, and your nonprofit was talking to us about a grant.
The nonprofit I was there on behalf of was Corpus Christi Metro Ministries, correct?
Yes, sir.
And you're a board executive member of the Coastal Bend Community Foundation, right?
That's correct.
And before that meeting, had you and I ever met before?
I don't believe so.
Okay. What I'd like to do for the tribunal and for our record is to just go through a little bit of your background. And so if you would just kind of give us generally an idea of your formal education, and then we'll talk about your certifications and your experience in the workforce, okay?
Okay. I have a bachelor's degree, a master's degree, and I was a student in the PhD program at UT.
Okay. And what are those degrees in?
Anthropology.
Okay. And I know that you have certain certifications. What are those certifications?
I don't know that I would say I had any real certifications, sir, in the sense that I'm not a CPA, I'm not a certified economic development person or anything like that.
What I'm referring to, and I have my screen somehow. Oh, there we go. I'm going to go ahead and show Exhibit 48-1. This is Respondent's Exhibit 48-1, which is a copy of your resume, and I saw somewhere where you have a certification of DBE/WBE. What is that a reference
That's just a federal certification that I was asked to get. It's a disadvantaged business enterprise.
Okay.
And in the state of Texas, there's also a historically underutilized business, and it's because it's a woman-owned business.
And looking at 48.1, is this, and I'll show you, I'll scroll through it. This is a 3-page document. This is your current resume, is that correct?
Yes, sir.
All right. It says you have 40 years of diverse consulting and government experience, including public engagement and outreach, facilitation, demographic research, social, economic, and financial assessments, management, and operational analysis and planning assistance. Read that correctly?
Yes, sir.
What does that mean in layman's terms?
I guess it means I'm a generalist.
A what?
A generalist.
All right. And it goes through several of the boards that you have served on. It says you served on a number of local and state agency boards, a former member of the board of the Corpus Christi Type A and Type B sales tax corporations. That's what we're going to talk about today, correct?
That's correct.
And it says you were an officer and ultimately president. It says you are currently at the Coastal Bend Community Foundation, as we spoke of, yes?
Yes.
You formerly chaired the Corpus Christi Infrastructure Committee, executive committee member and director on the United Chamber Board, and you are still a member of the South Texas Military Task Force, correct?
All of that's correct.
All right. It states that you published articles and presented papers at a number of regional and national conferences. Is that correct?
Yes, sir.
You actually worked for the city back in the 80s, I see.
I worked for the city, yes, in the early to mid-'80s.
And what did you do?
I started off in some contract work. I ended up in the city manager's office. I became an assistant to the city manager, and then I was appointed director of administrative services, which meant I oversaw 4 departments and co-managed a 5th.
Okay. And then after that, you went into consulting after that?
I was recruited back to consulting, yes, sir. I'd been in consulting before.
And I noticed in your resume, which the tribunal can go through on their own later, you did strategic assessment and plans for the Port of Corpus Christi, led by Booz Allen. Is that back in the 80s too?
I think that was in the early 90s.
Okay. And you were engaged to and you also worked on the what's called the Corridor Development and Management Plan for the Ports to Plains Corridor in 2004 and the Joe Fulton International Trade Corridor. What did you do in those kinds of projects?
In those kinds of projects, I was generally involved in preparation of communication materials, organizing public meetings, and public outreach.
It says you've worked with the City of Corpus Christi, the Port of Corpus Christi Authority, the Corpus Christi District of TxDOT, the Corpus Christi Metropolitan Planning Organization, the Corpus Christi Regional Transportation Authority, and both Nueces and San Patricio counties, correct?
Yes, all of them have been clients, or I've been a sub to a primary client of theirs.
I also noticed that you have interestingly worked back on the South Texas Spaceport Consortium. What was that?
Well, that's a long story. But a group of people got together and thought that they might want to explore having a spaceport in South Texas, long considered some years ago. And so we helped form that corporation, and then we did sort of the coordination for that group. I will say, ultimately, that group probably led to the interest of Mr. Musk and others in doing a spaceport down at Boca Chica. But we were not connected. No.
Must be fascinating to see that come to fruition.
It was interesting. Yeah, took a long time.
It also says that you have worked on 3 different desalination projects, including one for the Texas Water Development Board that analyzed a potential plant at the Barney Davis site. When was that?
I think that was in the first decade of 2000, somewhere in there.
Okay. And also one that looked at a potential of a plant on North Padre Island for the city of Corpus Christi?
That was a small plant the city wanted to look at as in lieu of putting a second pipeline to the island.
Okay. And the summary of your resume is, it says that you have experience working on multidisciplinary teams that include technical professionals such as engineering, environmental, planning, legal, economic, and finance experts. Is that a fair summary?
That's a fair summary.
And is that the kind of experience that you brought with you to the Type B board?
I hope so, yes.
Okay. I'm good with Exhibit 48-1, thank you. Let's talk about the Type B board. We hear the board, we hear the people say Type B, they say Type B board, they say different things. What is the Type B? What is it?
The Type B corporation is a corporation allowed under the local government code of the state of Texas, specifically 501 through 505 and onward, and that allows local entities to set up different types of corporations, and Type B is specifically addressed primarily in Chapter 505.
Chapter 505 of the local government code.
Of the local government.
And that's a statewide statute.
Yes, so that's the overarching, if you will, policies and statutes that we must adhere to.
And you said it's a corporation.
It is a separate corporation. We had to do articles. I actually began my service before the corporation was formed to the city. They nominated the board, and I was put on the board, and we had to do a certificate of formation. We had to pass bylaws, and then we are issued a certificate as a separate corporation under the state law.
So as a separate corporation, is that sort of structure something that's required by 505?
Well, yes, the 505 requires that you set up a corporation.
And does the corporation, I'm sorry.
I mean, to access the financial tools.
To access the financial tools afforded by the legislature in Chapter 505.
That is correct.
Okay. And does the Type B board as a corporation exist independently of the municipality that we refer to as the city of Corpus Christi?
We are appointed by the city council, but yes, we are a separate corporation.
Okay. And does the Type B board, or I keep saying board, I'm going to try to keep saying,
That's okay.
I'll try to say corporation.
That's what they call it.
Okay. Does the Type B corporation have its own rules and procedures and guidelines?
The corporation does. They're considered to be guidelines, yes, sir.
Okay. And those guidelines are published publicly, and they are actually approved by the council. Isn't that true?
That is correct.
Okay. And members of the Type B corporation are appointed. Is that true?
That is correct.
And what is the tenure of members of the Type B corporation?
6 years, and that's both in the state law and also generally the policies of the city of Corpus Christi. And it's 2-year terms, so you can serve 3 2-year terms.
Right, I got you. And so the corporation was formed in what year?
Yeah, I don't really, let's see, I can say that it was approximately, don't hold me exactly to this, but going back 6 years, about 2017, 2018 time period.
And who appointed you president of the board?
The board elects their own president, and I was elected by the members of the board at that time.
And the members of the board at that time were appointed by whom?
The city council.
All right. And who was the mayor at that time?
At that point, I'm not 100%. It could have been, let's see, 2023, 2022. It might have been Joe McComb or Paulette Guajardo. I'm not sure.
Well,
the 22, I guess it would have been.
I'm talking about in the formation, when it was first formed.
Oh, when it was first formed?
Well.
It might have been Nelda. I don't recall.
All we have to do is go outside and look
Yeah,
at those pictures.
I can look it up on my iPad.
So what is the mission of the Type B Corporation?
To spur economic development, Corpus Christi, Texas.
Okay. And Chapter 505 is our kind of guardrails for the corporation, correct?
Yes.
And how would you describe what Chapter 505 of the Local Government Code is in regards to operation of the Type B Corporation?
I think your terminology, guardrails, is it gives you the boundaries in which you can operate. You can certainly develop more precise boundaries in any given community.
And so if we were going to look at what the legislature allows a Type B board corporation to award economic incentives for, the first stop would be Chapter 505. Is that fair to say?
That's correct.
Let's go ahead and take a look at Chapter 505. And I've put up on my screen Local Government Code, Title 12, Planning and Development. And if you look down, it says Chapter 505, Type B Corporation. You see that there?
Just 1 second, let me get to 505.
Well, it also might be up on your screen right there in front of you.
Yeah, well, I'm better off looking.
Okay. You can use your paper copy if you'd like, that's fine.
Yes, I prefer, thank you. I'm there.
So what I want to do is just kind of scroll through with you, and I don't, obviously, I'm not going to go through every provision, but there's a 505-102 that refers to contract with other private corporation. What's that a reference to?
That gives the board the power to contract with another separate organization for either advice, assistance, and that was the case with Corpus Christi Regional Economic Development.
Right. The Corpus Christi Regional Economic Development Corporation is a contractor of the Type B Corporation. Is that fair to say?
That's a fair statement.
And Section 505.102 provides the statutory authority for that sort of
contract.
Okay. Are there some municipalities that you're aware of that don't have contracts like that?
I think there may be. I think at one point I was told maybe that Brownsville did it all in-house for their Type B corporation. In other words, they didn't contract with the city for any services necessarily, and they didn't contract with any outside economic development.
Okay.
So I imagine there's a range. There's any number of these across the state.
I'm just curious, is that that concept of having all of the Type B functions being brought into Type B and not having a contract with a contractor like EDC, has that ever been discussed as a policy that could be adopted?
I do not recall that being discussed here in Corpus Christi.
Okay. What I want to do then is go through a couple of the provisions that relate to specific projects that are allowed under 505, and I'm going to scroll you to, first we'll start with 505.155, and let me scroll down to that one. Let's see. And so 505.155, it says projects related to business enterprises that create or retain primary jobs. Yes. Are you there?
Yes.
Okay. And it says for purposes of this chapter, project includes land, buildings, equipment, facilities, and improvements found by the Board of Directors to promote or develop new or expanded business enterprises that create or retain primary jobs, including, and I highlighted too, any other project that the Board of Directors in the Board's discretion determines, promotes, or develops new or expanded business enterprises that create or retain primary jobs. The tribunal in this case has heard testimony from Mr. Culbertson that sort of along the lines of that Type B as opposed to Type A is kind of wide open. And I'm asking you, is this a provision that kind of gives Type B some broad latitude?
I would say that in my view it does, and that was one of the distinguishing factors that led the community group that went from Type A to Type B into adopting a type B rather than just reauthorizing a type A.
Okay, explain to that. What do you mean? What did you mean by that?
So we've had a former type A economic development focused, we have a number of type A activities, but one of them was specifically focused at economic development. When it came time, because it was passed by the voters for a time certain, and that time was coming up, folks got together, various folks, I think, and talked about, do we want to do this? Do we want to continue this? And if so, how? And at that point, I think that group decided to move to type B.
Okay. And
For the fact that it was broader, and I think one of the particular motivations was it was clear that some of that money could be used for streets.
that was an important issue in
That
Corpus
was an
Christi.
important issue.
Still
maybe,
is.
Maybe so, yes.
All right. If we go up, and 505.155, this one relating to jobs, the incentive in this case, jobs was, it's fair to say, part of the consideration the Type B board put in when it decided what to do with the application in this.
At this time, excuse me, Ms. Olivari, we'd pose an objection. Right now, he's asking the questions about what type B board considered. I don't have any problem if he rephrases the question to ask what this witness considered or what her considerations were, but for her to offer testimony about what other members of the board were thinking would be speculation, so that a legal objection is speculation. And I'm going to therefore make the technical objection that he's asking a question that calls for her to speculate about what other members of the board were thinking whenever they did things. Again, I don't have any problem at all with him asking what she considered and what she thought.
Mr. Flood, if you could rephrase your question.
When I ask you what the Type B board considered during my questions today, I'm going to be asking you for your own recollection about that, okay? And also, if necessary, I will specify what the Type B board's sense was, as you sometimes will have done, as we will see, which is you ask to clarify from your board, and then I'll ask you whether or not this is a personal thing. So
I welcome that, yes.
Okay.
I prefer to answer for myself, unless I specify otherwise, because I'm on the record.
I appreciate that. If she's specifying that when she's answering for herself, unless I hear something broader than that, I'll speak up, and I understand that otherwise. Thank you.
Thank you.
And so under 505.155, when you, in your role as the Type B, as a member of the Type B Corporation Board, considered this incentive, was jobs part of the consideration that was it part of what you understood to be a consideration?
Yes, in this project, I would say it was an element, not the only element.
And it was an element, and the contract in this case, if it does not refer to 505.155, is it true that the actual incentive itself that was approved does include a jobs element?
It is true that the contract we have with the hotel company included a jobs requirement that they would meet.
Okay. And what the contract refers to is section 505.152, which is the section I've now put up, projects related to recreational or community facilities. You see that there?
Yes.
And I want to make sure that this is correct, okay? I have highlighted for purposes of this chapter, project includes buildings, equipment, facilities, and improvements found by the Board of Directors to be suitable for use for, I highlighted, entertainment, tourist, open space improvements, and related restaurant and other related improvements that enhance any of the items described by this section. Are there any other portions of 505.152 that you believed, and I'm asking you in your personal capacity, that you believed applied to this incentive?
Under that section of
Yes.
yeah, I mean, I think it was the retail component,
Okay.
yes.
And
I need to clarify one
Sure.
thing. So, at least in my mind, the reason that the jobs were important was because we need to have more employment downtown. It might not have necessarily met the test of primary employment, but the goal was to activate downtown. And that, I think, that was my thought about why we would tie in the jobs. In other words, we weren't just going to build an empty box.
And thank you. You can take down 505. When we say that Type B funds and the criteria for granting incentives under Type B are broader than Type A, explain if that, first of all, if you agree with that, and if you do, explain why that is true.
Well, under Type A, you really are limited to manufacturing and primary jobs. Primary jobs can be a little broader than that, but my understanding is it's sort of jobs that involve some sort of export, and that was of some goods or services, and so that was more limiting. Type B gave you more opportunity to do community facilities, consider infrastructure improvements, et cetera.
Okay. And earlier, the tribunal heard some testimony from Mr. Culbertson in a deposition that he gave last year in a lawsuit that the Type B board has published guidelines, correct?
That's correct.
All right. And what are the purpose of the guidelines?
I think the purpose was to make sure that an applicant, the CCRADC as advisors, the staff, city staff, and the board itself, the corporation itself, and be known therefore to the public in general, what criteria or what we were looking for in projects and how we operated.
And the availability of Type B funds to the community for all different parts of the community, is that important to the Type B board corporation? And I'm going to speak, I'm going to ask you, I'm asking you personally, but is it important to you personally that the guidelines and the understanding of the community that these funds are available, is that something important to you?
Absolutely important to me.
Okay. What I'd like to do is now show you what has been admitted, and this is, oh, wrong one. Wait a minute, where is it? Peter, what number are the guidelines? Oh, I don't have it for some reason. 1 second, technical problem. Here we go. All right, I got it. Let me show you what has been admitted as Respondents Exhibit 48, and I will represent to you that this is the version that was in place, approved on August 31st, 2021. The Type B guidelines were changed at some point in July of 2024. Isn't that true?
That is true.
It was after this incentive agreement was approved by the council here on April 23rd, and after you signed the contract in this case, correct?
That is true.
Okay.
And I'll add one thing.
Yes.
The guidelines, I think, had been amended from the day that they were first constructed, maybe once or twice, leading up to 2021. So it was a document designed with the council's sign-off, if you will, to be recognized changes or things that may have occurred.
Do you know whether the guidelines that were amended in July 2024 have been approved by the council?
I don't. My term essentially ended in August of 2024. I know that we passed them with 2 key provisions that were brought to us by the staff, somewhat as a result of this. Let's
take a look at these. I did a couple, these are the guidelines, and these are, as we see, it says, stated desire of the corporation's board of directors that funds approved for the promotion and development of new and expanded business enterprises can only be used for any eligible project under Chapter 501 and 505, right?
Yes.
Okay. And these guidelines adopted state, whereas to assure a common coordinated effort to promote economic development, these guidelines and criteria have been circulated among the city, other governmental entities, the EDC, Area Chamber of Commerce, and the community in general for consideration. How does that happen?
Well, I mean, they're published on the city's website because they're an action of ours. Certainly, they were directly distributed to somebody like CCREDC. I cannot personally say that they went to the Chamber of Commerce. Obviously, the staff would have them.
They're publicly available.
They're absolutely publicly available.
I'm going to go down to section 2. Well, first of all, I'm going to do a definition here. There's a definition of CCREDC means the Regional Economic Development Corporation, which serves as a professional economic development advisor to the city, the corporation, the board. What does it mean by, what is your understanding of the guidelines meaning of the term advisor?
That they would provide us their professional advice in order to help us reach a decision or consider an application or a project.
Okay. I want to ask you about, and then the guidelines go through well, first there's the mission and goals. It shall be the mission, and this is on page 4, section 2. It shall be the mission of the board in administration of these guidelines and criteria to promote, encourage, and enhance the expansion of the city tax base and economy through granting business incentives, and that the goals are accomplished through creating and retaining jobs, expanding the city tax base and economy, and strengthening and diversifying the local economy. You see that there?
Yes, sir.
There's next section, it says what this EDC is responsible for. And the EDC, fair to say, receives the applications, processes them to the Type B board, and then if there is an incentive granted, the EDC then manages compliance. Is that fair to say? Is that a fair summary?
That's fair to say.
Okay. I want to go down to, then there is section 3, we see business incentives authorized, and then we see in these different sections, we see different types or descriptions of incentives that the Type B corporation, under their guidelines, will consider. Fair to say?
Fair to say.
Okay. I want to go down to section 10 first. And section 10 states, projects under this section can be any project allowed under Chapter 505. Tell us about that section. What does that mean?
Well, there are other projects that are allowed under Section 505 for specifically some educational things like internships. There's just a list of other projects that can be allowed.
Okay. And so if there is an incentive reason that's included within 505 that is not specified here on your guidelines, what Section 10 is saying, we'll consider anything under 505.
That's my reading of it, yes, sir.
Okay. And if we go up Section 9, it says the grants are limited, this says certain targeted infrastructure. Grants are limited to streets and roads, rail spurs, water and sewer utilities, and those types of things. And then it says, especially in locations that eliminate blight or areas of high unemployment, such as Texas enterprise zones, Texas increment reinvestment zones, and other reinvestment zones and opportunity zones. The hotel that's the topic of our discussion today. Is it in any of those?
Yes, it is.
Okay, which ones is it in?
It is definitely in a tax increment zone. It is, I believe it's also in a federal opportunity zone, or was at that time. It meets the criteria for a blighted area with certain economic challenges.
And then under universal requirements, these are ones that the particular Type B board adopted that are going to be applicable to all incentives, or is this applicable to some, or Section 11 universal requirements?
Well, yes, for example, if we funded a job, then we had certain requirements that were universal relative to the wage levels, relative to provision of healthcare insurance and other benefits.
Right, so if we go through, there's project implementation has to be started 2 years from the date of the agreement. There's certain location and residency requirements, living wage requirements. If we go through this, health insurance, utilization of local contractors and suppliers, things like that.
Things like that.
Okay. I want to ask you about Section 13. And it says, Section 13 is entitled Approval. And it says, reservation of rights. The board reserves the right to determine the eligibility of a project and the terms and conditions of any loan, grant, or guarantee based on the mission goals and objectives in Section 2 above, correct?
It reads that, yes.
And then it says, nothing herein shall be construed to limit the authority of the board to examine each application for business incentives before it on a case-by-case basis and determine in its sole and absolute discretion whether or not the proposed project should be granted any business incentive and whether or not it complies with these guidelines and criteria, is feasible, and whether or not the proposed business incentives will be to the long-term benefit of the city. Did I read that correctly?
You did.
That is an extraordinarily broad grant of approval, or extremely broad grant of discretion afforded to the Type B corporation. Would you agree with that?
I would agree with that.
And that guideline was approved by a city council, true?
That guideline was developed in concert with the staff, the EDC, approved by the corporate board, and then this council has to approve or ratify it, I would say would be the word I'd use.
Okay. Let me go back up. There is a discussion in Section 12 about how application for Type B money, Type B funds works, correct?
That's correct.
And there's a discussion in 12C about a feasibility economic impact study, and it says, after receipt of a completed application, the president of the EDC shall cause to be perform an economic impact report. You see that there?
I see it.
What is that about? What is the economic impact study?
So in our case, I believe the CCREDC primarily relied on what is called a RIMS model, which is a...
Excuse me just a second. We would just object to her talking about what CCREDC did that she did not participate in. She needs to limit, I think, her testimony to her personal knowledge.
I believe they were our contractor, so I should know what they did.
Well,
I'm not arguing with the witness, I promise.
I'll
give my chance in a minute.
I'll address it.
Okay.
So when
I don't mind her testifying about their processes generally.
Thank you.
the EDC, under these guidelines and under Chapter 505, is an advisor to the Type B board, correct?
Correct.
Okay. And one of the things, based on your personal experience as chair of the Type B board and your understanding of 505 and these guidelines, one of the things that the EDC is expected to do is to perform some sort of economic impact assessment of a proposed project. Fair to say?
That is fair to say.
Okay. And if you would, based on your years of experience at the Type B board, what is the purpose under these guidelines of the economic analysis prepared by the EDC?
Well, I think it's to give us some sense of the economic impact, what would be the benefit economically to the community.
Okay. And what are different models that are referenced in the actual guidelines here? What are the, if you can, tell us what those are.
Did you pull that up for me?
Sure.
Are you saying the job creation, employment? I mean, they don't name specific models that I see.
Actually, it says this report, it says after receipt of a
In
complete.
plan, yes, I see it.
Okay. This report may be completed by CCREDC or its consultant using established, accepted economic impact models such as, and I'm going to ask you about those. What is in-plan?
It's another form of estimating economic impact.
Okay, and what kind of inputs go into an in-plan?
I can't say specifically what goes into the in-plan. You know, I can't answer that.
Okay.
I would say that these models, I do know, vary as to what they take into account, so.
Okay, and it also refers to the RIMS 2 EMSI, and it says, or similar model. Do you know what the EMSI is a reference to?
Don't know that one specifically. I've never worked with that one.
Are you familiar, and were you familiar in 2023 with the RIMS 2 model?
I had worked on projects where RIMS was used, yes, sir.
Okay, and what is the RIMS model?
It primarily relies on the employment to be generated and the estimated wage of those employees, and it can be run with different assumptions. For example, you could run it for a 5-year payback or a 10-year payback. My understanding, and again, it's just me, I'm a layman, I'm not an economist, but there are different levels of RIMS that you can purchase, sort of a basic level, and then it can get more in detail.
And do you have, in 2023, do you have any idea what the RIMS model or what RIMS 2 version the EDC had paid for or not paid for?
I just think, but this is a question for Mr. Culbertson or somebody, that they had the fairly basic RIMS model.
And that was based on your discussions with them, that was your understanding?
That was my understanding.
Okay. And when you said certain assumptions, what are you talking about when you say the model, you can input certain assumptions? What's that a reference to?
Well, you can say you want to pay back in 5 years, you want to pay back in 10 years, you want to pay back in 20 years.
I see. And
as an example.
What other kinds of inputs or alternate inputs are there in this sort of economic modeling?
I don't know specifically. Again, I don't pretend to be an expert. I would say I don't believe in this case that model included things like sales tax.
Okay. All right.
That's my understanding.
Okay. And are there any, from the standpoint of economic development and being on the Type B board and the kinds of decisions that you made on the Type B board, are there any issues that you had or have today with that sort of economic modeling, in your opinion?
No, I think it's a piece of information that you can use along with other information in decision making. I mean, it's not a determinant.
And when you say it's not determinative, what do you mean by that?
I mean that I think there are other things you could take into account when you decide on a project.
Going back to the guidelines and referring to the model itself, it says this study shall include but not be limited to an estimate of the economic effect of incentives, job creation, employment enhancement, capital investment, and it says that the costs of the study shall be borne by the EDC, and it says that the economic impact report should clearly identify the direct and indirect economic impact of the project. And so in this particular instance, when the approval from the EDC board came to the Type B board, did the economic impact report, in your recollection, did it include did it show clearly the direct and indirect economic impact of the project?
I assume that the number they provided us was the compilation of direct and indirect.
Okay. So if the recommendation was 1,043,000, and that was the exact same number that the RIMS 2 model produced?
That would be what I would assume they gave to us. I would think that would be the right thing for them to do.
Okay. The right thing to provide to you?
Yes.
Okay.
The results of that model. I don't think they, and I think they did it with a 5-year, when they looked at ROI, they were looking at 5-year return.
Okay. And the, what weight, and you can speak on behalf of yourself as the board chair at the time, what weight is the EDC board recommendation given at the Type B board corporation?
I think we considered them to be a valued advisor, and we certainly listened to their opinions. But I would say that the board, I would also maybe consider other things.
Such as?
Than they did.
Like what?
Such as.
Excuse me 1 second. He said they did. I think he needs to ask what she did.
I'm going to answer me as we agreed, sir.
Thank you.
I considered things like what I would call induced activity in downtown, the liveliness of the street, the, you know, other than just what was the economic pay.
Okay. And those sort of considerations are permissible under Chapter 505 and the guidelines that were adopted by the Type B Corporation and approved by the council?
It is my understanding they are.
Okay. And one of the things that before the Type B board receives an application, legal here at the city makes sure that the application qualifies for Type B, correct?
Checked form. I don't think that's outside her expertise, but I'll let her.
Well, my understanding of the process, at least the way, if I was ever approached by anyone about a potential project, I did not like to get involved in a project until it was presented to us. I would encourage them to go to the CCRED staff, that they were the gatekeeper, if you will. They were the ones that could advise somebody on what was required and the application process. My understanding is that they would then coordinate with the appropriate city staff, including the legal department.
And you were here earlier. Were you here earlier when Mr. Culbertson's deposition was played?
Well, remind me what you're. Yeah, I was here, but.
Well, that's okay. So what I want to do is turn your attention towards the incentive that we're here to talk about today, okay? And what is the first step that the Type B board, in your recollection, 2023, what was the first step in this incentive that you recall the Type B board taking?
So we had a closed session, and this is a standard practice on a completed application and one that was either recommended or not recommended by the board of the CCREDC. We had a closed session, and in that session, staff of CCREDC, city staff, including, let's say, in this case, Ms. Holbrook.
Excuse me, and I'm not trying to interrupt. I just want to point out, if we're going to talk about what happened in closed session, that I'd be allowed to cross-examine on closed session.
I will not speak about what was in closed session.
I'm not trying to argue with you, ma'am. I'm just trying to make it clear that if we're going there, we're going to go there, and if not, then I'll trust in you.
All right.
Following those guidelines.
Our process was normally to have a closed session with the appropriate people there.
And who are the appropriate people? And you can just provide us with the categories of those people.
Legal, city management, and CCREDC.
And when you say city management, you're referring to Mr. Zanoni or one of his assistants or both?
Yes.
Okay. And I'm talking about in the 2023 timeframe. Yes. Okay. Now, what materials are received by the Type B board, and without regard to what was discussed in the closed session, but at that point, when you have your first closed session between where the board sits, who's in attendance, and the city staff that you just referred to, and the EDC staff that you just referred to, what materials have you received at that point?
Nothing in writing.
Okay. And so how is it that the topic, without regard to what specifically the topic was, how is it that the topic is actually even raised in the context of a closed session? Do you understand my question?
Our standard practice was to rely on the CCRDC staff when there was a completed application and it had been voted on or recommended or not recommended by their board, to bring that to us in closed session.
Okay.
That's without regard to this.
Okay, so without regard to what was said in this closed session, the normal practice at the time was that in that closed session, and let me make sure I understand something. The Type B corporation publishes an agenda and for public consumption, and that agenda describes that there's going to be a closed session. True?
That's true.
All right. And so if we were to go back and look at the agenda there, it would state that there's going to be a closed session, and what would be the description typically of that closed session?
It would provide what state law we are meeting under, and it may sometimes reference a project or at least a type of project in that, to give some notice we're considering some type of project.
And so to be clear, when you arrived at the Type B board meeting that day, you had not received anything in writing or anything related to this application that had been submitted by the hotel developers. Is that fair to say?
I thought I had said, I had a call some weeks before from Mr. Ramirez, and he asked me to come by his office to talk about a project.
Okay.
I went to his office. He began to tell me about this project, and I said, Philip, I don't do this. I rely on, as a board member, I'm not really interested in getting into any details about a project. I rely on the CCREDC staff to act as the people who bring a project to us. And so I think that, I actually think it was less than 30-minute meeting.
Okay.
Now, by the way, I want to say something. Other board members may have done something different. I can't speak to whether they had been advised in ahead. I don't know.
Okay. And so when you arrive at the meeting, you have not received an application prior to the meeting?
I had not.
Okay. And is it typical practice at a Type B meeting on that first closed session, is it typical, and I'm not necessarily asking about this particular instance, but is it typical to go through the application that was made?
We just object.
Yeah.
That may be a specific she doesn't want to go into, but I'm just raising the flag. Everybody talk.
Okay, well, and I do not mean to, I'm just asking in a typically, not specific to this. And again, I do not intend to cross any lines related to the closed session. Okay. Let me just ask this. At this very first closed session on this item, as we've already gone through, there's city management there. Is city legal typically in these meetings at closed sessions?
In our, I believe, actually, they are required to be in all closed sessions of this, that pertain to city. So I will say that in general, yes, they would be there, just like the city secretary would be there. I believe they are required under other state statute open meetings.
Okay.
I could be corrected, but
Pardon me?
I could be corrected.
And it's my understanding that without regard to what was stated, there would be someone from EDC there, such as Randy Almaguer or Mike Culbertson?
Our practice was, in any matter, to rely on our advisors for them to provide us the information we needed to understand the project.
Thank you. And at a E-session, typically is, and one on a incentive like this, is there anyone from city engineering that typically attends those kinds of meetings?
If that was a necessary advisor to a project.
You just don't have any independent recollection. Well, I won't ask you.
No, you're not going to ask me that.
Okay.
I won't go there.
Now, what I want to do is ask you, and I'm going to ask you your own personal state of mind after the meeting, okay? Which is a way that we lawyers try to address this issue of the E-session and executive session and closed session, okay? As a result of that first executive session, did you have an understanding of the concept of funds, Type B board funds, being used for downtown revitalization?
I was shown by you an email that I'd never seen that I believe went from Randy to the developers. So I will say that in that email, he outlines questions that we had asked the developer. Okay. And since that's public information, I'll say yes. And that would not be unusual on any project for this one or any other to send back questions to the applicant.
Okay, and we're going to go through that email in a minute.
Okay.
I just have a couple more questions I want to ask you. After that E-session, that first E-session, did you have an understanding of the concept of a term we've heard a lot, street level activation? Did you have an understanding of it at that time?
Well, I had my own understanding of that before, yes, but I did.
Yes, and if you would, for the record, when we hear street level activation, what does that mean?
I think, I will say this, in the subsequent meeting on December 11th, we discussed that, and we stated that in the motion that we passed, we stated that what we were looking for was retail, including restaurants that were directly accessible from the street, that were visible and accessible. So you didn't have to go inside and access them. As you walked down Chaparral or Mesquite, what you saw was an open place, not just a wall.
Okay.
And that's what we meant.
Okay.
People coming and going.
And is that a development term of art, street level activation?
I would say it is, I guess.
Okay.
Urban planning kind of term of art.
Urban planning term.
They come and they go, words like that.
Okay. And let me ask you this question. After that E-session, did you have an understanding of the concept of spending Type B funds to address general FEMA floodplain compliance?
Again, I would like to refer to December 11th. We had an E-session there, and in that meeting, for the record, in public, it was stated that what we were funding and interested in was this street level activation, this retail, and that.
Okay. And we're gonna get there, but but first I want to go back to that email that you referenced just a minute ago.
Okay.
Okay? And let me bring up, oh, I'm looking for it. All right. No, here it is. No, where's 69? I apologize. Don't bring it up yet. Here we go. Let me show you a document that has been admitted as Petitioner's Exhibit 69. Do you see that there?
I do.
All right. And if you go down to the bottom of it, the way emails work, you always got to start from the bottom up. There is one that it's there. It's Elevate 194. You see that there, that bait stamp at the bottom of the page? Is that a yes? Sorry.
Yes.
Thank you. It's an email from Randy Almaguer, and remind us who Mr. Almaguer is?
He was a staff member working for Mr. Culbertson and PEDC, and he tended to be a liaison for our board and also did the compliance.
Okay. And this is an email to Mr. Ramirez where he says type B follow-up. And so the timing of this, November 14th, this would have been after your closed session, the executive session we were referring to a little while ago?
That would be the next day.
Okay, the very next day. And he asked you some questions here. He asked Mr. Ramirez some questions. He says, number one, can you provide me proof of financing? Correct there. And because this is now a public record, it has been admitted in this proceeding, I'm going to, ask you content included in this that possibly would expose some of the thoughts that came out of your e-session. You understand that? And so I'm simply going to let the record reflect. I got some snickering of the nose in response to that predicate. So I'm going to ask you some of these questions, and again, if you are not comfortable answering any of them because of your conscience and wanting to pay attention to the need to keep things closed, please make sure that you do that, okay?
Well, for other people who are listening, I want to explain my position about that. I'm not trying to obfuscate in any way, shape, or form, but under my reading and under the advice that I've been given about the Texas Open Meetings Act, those are confidential sessions, and I would be at risk of breaking the law if I disclosed as well. So I'm not doing this just because I want to obfuscate. It's because, as the council knows well, that's we have to adhere to state statute.
And I appreciate that, and I certainly do not want to put yourself or myself or anybody in jeopardy of that, okay?
Right.
All right. So going back to Exhibit 69, it says, number two, can you provide the cost breakdown of the additional build-out of the retail space of $489,912.50, like the FEMA additional cost pages submitted? Did I read that correctly?
Mm-hmm.
Will the 70 FTEs, what's a FTE?
Full-time employee.
Be for the hotel or a combination of hotel FTEs and tenant FTEs? And then that last one is number 5. Can this project move forward without the $2 million grant and reimbursements? You see that there?
I see that.
Okay. And so Mr. Almaguer at this point is asking questions of the applicant, and he is doing it because these are questions that the Type B board has asked him to ask the applicant. Is that fair to say?
Or questions that he, as a staff member, may have.
Okay.
I can't necessarily say whether those were the representation.
Okay. And so that was on November 14th. If we look up, it's now been 2 weeks have gone by. Tuesday, November 28th, and Mr. Ramirez has not responded yet. He says, Philip, hope you had a good Thanksgiving. Putting this back on the top of your email. The next Type B date is set for December 11th, and that was going to be the first public session, correct?
Potentially, yes.
Potentially, right, potentially. I'd like to place this item on the agenda, and we see that Mr. Ramirez responds on December 4 at 7:42 in the morning and provides some information, correct?
He does.
Let me try to blow that up for you. I
see it.
apologize.
I see it.
First one is he says there's a relation to the PowerPoint presentation. He says we can use the same as TERS and I can tailor it for the Type B meeting. I think that was a statement by Mr. Almaguer, and he says, okay, sounds good. And you understand that the bold responses appear to be from Mr. Ramirez, correct?
Understand.
All right. Under 2E session questions, can you provide me proof of financing? And he says, see attached letter. We don't have that letter, but I'm just showing that to you. And then he goes into, can you provide the cost breakdown of the additional build out of the retail space, like the FEMA additional cost pages submitted? And before we go through that, I want to understand your understanding at the time in December of 2020 or November of 2023. What is this reference to build out of the retail space? What is that?
Well, there are distinct requirements under the building code and other codes. If you are going to build, let's say, what they call gray box, as opposed to retail with glass and doors and things like that to the street. That would be my understanding.
And what is, when we see the word gray box, what's that a reference to?
That means an interior space without build out.
Okay.
Or that's what I think. I'm not an architect either.
Well, your understanding back at the time when this question was posed, your understanding of the term gray box would fit with what he's referring to as build out of the retail space. Is that fair to say?
Yes.
Okay. And so he says on, Mr. Ramirez responds, glazing facing chaparral and outdoor dining, and then he gives a $210,000, concrete fit at outdoor dining patio, $50,000, covered seating and shade canopies, $35,000, grease trap and utilities, $45,000, gray box finish out for 3 lease spaces. And what are the 3 lease spaces? Your memory of what this project include from the standpoint of 3 lease spaces?
Going into December, the idea was that we wanted to see street-facing retail on Chaparral, on that side, and that would be walls or windows, or it's finish out. I mean, it might be, it depends on what he anticipates his tenant use to be, whether it's actual retail or an ice cream shop or
And so the retail gray boxes are a component of what we refer to as street level activation. Is that fair to say?
Well, I would say gray box means it's not really, what's the word, designed out for a tenant. It's just sort of vacant space that can be tailored for a tenant.
For a tenant to come in and make it what
Then make it what it needs to be, yes.
Okay. And you said an ice cream shop, it could be a restaurant, it could be...
It could be shopping.
Okay.
Retail store, typical retail store.
And is that kind of development, and I want you to speak for yourself, is that the kind of development that intrigued you about this project?
Yes, sir.
Why?
I think at one point I may have even said in one of the meetings, because I feel like when people come to Corpus Christi, whether it's on business or in tourism, you want to spend some money, and you want places. In many cases, you don't have a car, you don't want to go to a car, you want places to take out your credit card, and I thought we had too few of those to capture sales tax, which I would point back was beneficial to the corporation itself.
Good for the city.
It's good for the city, it's good for downtown, and it's good for the sales tax.
Those things being the objectives of the Type B Corporation.
I would say they meet some of the goals of the Type B Corporation.
Okay. Let's go down to the next one. He asked about the 70 jobs, and he asked, are those for the hotel or a combination of the hotel? And earlier, a minute ago, we were just talking about the tenants, that'd be the ice cream shop, those kinds of things. This question relates to, when you say you're going to have 70 jobs, are you including those? That's what he's referring to, correct?
Well, I believe even in January meeting, we wanted to clarify exactly in public what those 70 jobs were. Were those hotel staff? Was that the servers in the restaurant, new restaurant? Was that retail counter?
And Mr. Ramirez says this is hotel only, and then he makes some sort of estimate as to how many employees.
Again, as we said in January, I believe, or it might have been the December meeting in public, you know, the retail space could have been leased out. So if there were jobs associated with that lease space, we didn't want to count those. That was separate. We wanted to know what the basic employment of the hotel, because it was, frankly, because it was easier to do compliance. We could hang our hat on that, and that's what is included.
And when you say compliance, you're talking about once the monies are paid to the applicant, if there's an approval of an incentive over the 5 years or whatever it is, EDC does the compliance in that regard, right? They check the compliance.
The requirement is that the applicant gets no money until they have demonstrated that they have met a certain level of employment. And if it's somewhat less than that, then the money is available over a 5-year period. So they would get $400,000 each year. And each year, depending on what the contract says, they have to meet that level of employment. If they don't, then the award is diminished percentage-wise accordingly.
Okay.
And that's why it's important.
The last question that's posed here and that was answered back in December of 2023 is, can this project move forward without the $2 million grant and reimbursements? And it says this project's underway. However, if we are unable to secure the full grant of $2 million, we will only have the available loan equity funding to provide shell space for the rooftop bar restaurant, and will not be able to provide for gray box finish out outdoor dining for the first floor lease spaces facing Chaparral to align with the opening of the hotel. That issue of the gray box finish out outdoor dining, based on the Type B board corporation board's recommendation, was that something that was important? And I'm asking your recollection of the Type B board's, the sense of the board and its reason for the policy that it adopted. Was that preserving that gray box finish out outdoor dining for the first floor lease spaces important?
I will say in public at our December meeting, we indicated that we thought it was important to have that element in the project.
Okay.
Those elements, there was more than one, yeah.
Among other elements that were
Well, I mean, it was the restaurant, the retail. It wasn't just a single. It was both on Chaparral and on Mesquite.
Okay. And it says the funds to complete those phases of the project would not be available until the hotel is stabilized and running at full capacity. That could take up to 3 to 5 years, given our debt service and operational costs. Even then, if the operating margin does not provide the available funds to justify the build out of those 2 spaces, it could be an even longer duration. Did I read that correctly?
Yes, sir.
And we see that Mr. Ramirez actually provided those responses on December 5th at 2:05. You see that there?
I do.
There has been a use of the term, and you can take down Exhibit 69, please, Petitioner 69. Thank you. There's been a use of the term "but for" in regards to if this incentive was not granted, what would happen? Does the email we just went over, at least from the applicant's standpoint, address the issue of but for?
I would say my sense was that, like any project, it had certain budget limits, and that without our incentive, additional money, the build out of that retail space would not have happened in the immediate time frame.
Okay. And you personally, was that important to you?
Again, yes, because I mean it's how people measure and active in revitalizing downtown, and revitalization of this area, this blighted area, was certainly very important to us. We had funded other projects, including one sort of next door, and we were geared towards helping the areas, including the west side and other areas that needed revitalization.
Okay. And the board was scheduled to meet again on December 11th, correct?
That's correct.
And prior, I'm not going to ask you about the E-session that happened, but at that meeting on December 11th, there is an executive session or closed session that happens as part of that meeting, correct?
That's correct.
All right. But also as part of that meeting, there was a public session as well.
That's correct.
And where did that public session happen?
I think we were meeting upstairs. I believe at that period of time, the council chamber was under reconstruction, and even the council was meeting over at the RTA. So I believe it was in City Hall, but on the 6th floor.
Okay.
I think that's what I remember.
And in the public session, it is true, is it not, that you addressed the concept of spending Type B funds for wholesale FEMA compliance. Isn't that true?
That's true.
Okay, I'm going to show you what has been admitted as Respondents Exhibit 50. Let's see if I can do my computer here correctly. If I don't. And I'm going to show you this, and this is a clip from the December 11, 2023 Type B meeting, okay? And this would be the public portion of the meeting as opposed to the, obviously, the executive session, correct?
Correct.
All right. And before we watch this, is the executive session first, or does it?
Yes.
Okay, so you have now come out of executive session.
Yes.
And if we look at this image here, down at the bottom, there's two tables we see. That's you in the red jacket, correct?
Correct.
And if you would, tell us who else that we see there sitting, your board members there.
Going from the left, that's Mark LaRue. Next to me on my right is Alan Wilson, Diana Summers, Mr. Evans, who is no longer in Corpus Christi, who is with the hospital, and J.J. Jimenez, who is an engineer.
And down at the bottom, who do we see at the table sitting below?
On the far left is a staff member, Joe, who worked at that point for Heather, was sort of a liaison for us. I think that's Joe. And then Philip Ramirez and Devin Bachman.
And let me go ahead and play what you said publicly on December 11th, 2023.
Let me say one thing. I think my sense is that we are doing this not because of the additional flood or FEMA or any of that. I think it's fair to say that this board felt like that this would be a catalyst for downtown, and it was a new type of development. We'd like to see that spur it on, but we're not open to a continuous a project involvement. It's a case-by-case basis. Is that a fair statement, everybody? Yes. And so I just want it on the record that it's because it is a blighted area, because it is a catalyst, that was the reason to move forward with the investment. And even though it was somewhat more than the general economic analysis that we do and respect would have called for. We felt like there would be that level of value to the overall area.
What did you mean when you said overall, a level of value to the overall area?
Well, I guess speaking personally, I think, and for the board too, the fact that if you're...
Excuse me, if you'll limit your comments to yourself, not to the board.
Sure.
Let me address that for a minute. During your statement, you stated, after you said, my sense is that we are doing this not because of the additional flood or FEMA issues or any of that. I think it is fair to say that this board felt this would be a catalyst for downtown. And you asked, is that a fair statement, everybody? Why did you do that?
Well, for better or worse, I read the procedures and the guidance given by the city council on being a board member and a chair. And as I read those, it says that the board chair should sort of summarize the action and the reasons for those actions. So that's why I did it.
And was that a practice of yours as the Type B corporation chair?
I tried to, yes, sir, to follow those guidelines.
Okay. And so you have expressed to us the reason why you asked your board members, is that a fair statement? True?
Because I would very much like anybody to correct the record if I had misstated.
Okay. And why did you make this public statement?
I made this statement because the idea that this fund would be the stop and go, if you will, for any needed upgrades or anything general, I would say holistic addressing FEMA. Whatever the circumstances, I did not feel like we had enough money. By the time we had a number of projects come to us with a similar type of approach, we would have used up our available funds. And I always strove to be equitable if we made a certain allocation to a certain project, then I thought it opened the door for us to fund a similar project for a similar reason. And that's why I did it.
So in that statement, were you addressing the concept of spending Type B funds for wholesale FEMA compliance?
Personally, I never thought that we could, I never thought it was a good idea for us to try to go back and say that, well, the FEMA rules have changed and we need to make it, we need to make projects kind of hold them harmless from the changes in those rules. I didn't think that was not going to be a viable path forward for the board. That was my opinion.
Okay. And when you made that statement that we just heard, and you stated that we are not, that my sense is that we are doing this not because of additional flood or FEMA issues or any of that. Why did you make that particular statement?
Well, because it obviously had been presented to us. I mean, you can see it, but well, what happened was we were moving along with this project, and then these new floodplain rules came in, and they caught us off guard, and that added to our cost. And we were not funding that. Lack of information, misunderstanding, we were not going to fund those differences.
That rationale or narrative, so to speak, was rejected by you. True?
Yes, and I think that's what my statement was trying to address.
And when you asked your board that, is that a fair statement, everybody, What the sense of your board was that you were rejecting the narrative that you wanted type B incentive money to address this concept of wholesale FEMA compliance, whether it's a surprise or not a surprise.
Excuse me 1 second. Just object, that would be speculative into the minds of others.
I'm asking you as a result of all the deliberations and then the statement of a public policy by the Type B board makes policy, doesn't it?
We sign contracts.
Okay. The policy that was declared in open record, in an open meeting on December 11th, 2023 is that you were rejecting the notion of Type B funds being used for wholesale FEMA compliance. Isn't that true?
In understanding he's asking her if she rejected it, I don't have an objection. Go ahead.
I rejected it.
Yes. And you made that statement, and then you said, is that a fair statement to your board, correct?
I did.
And you did it for the reasons that we've already talked about, true?
I did.
Okay. Because you believed that it was your duty to provide the sense of your board, true?
Object form leading.
Rule 611 does not apply to this proceeding. So my response to that objection is that section of the rules has been abrogated. Thank you. That statement I just made is that that public declaration was made because you wanted, the board wanted, and you asked for them to agree to this. Is that a fair statement, everybody? And the fair statement being that we want it to be a public policy declared on this board, here for everybody to hear, that wholesale FEMA compliance, whether it's a surprise or not a surprise, don't bring us that. We're not going to pay for that. Fair to say?
That's fair to say.
And going back to it, and I'm sorry to have to do it again, why did you make that statement?
Well, because we had been presented from the CCRDC a recommendation that it be funded, that it would be funded in order to, or at least there was an idea that part of the funding was maybe based on this change or upgrade on the FEMA requirements. And so.
And whether the applicant.
And that was actually kind of a presentation by the applicant. So
Right.
we didn't want to see that as a precedent, I would say.
And whether the applicant was surprised or not surprised, or whether that was a genuine narrative or not, immaterial to you.
It was absolutely immaterial to me.
And that was true in 2023, right?
In 2023.
Because December 11th, 2023 was the Type B board's decision day, right?
That was, yes, that was our public first decision day.
Whether the applicant was surprised or not surprised by FEMA, was that of any concern to your board at all?
I will speak for myself. It was not a concern.
And was there ever, and I don't want to disclose any e-sessions, but was there any sort of thought that the Type B board is not going to be a bank for FEMA compliance?
That sounds like a fair way to look at what we didn't, or I did not think we wanted to be.
Okay. And it's fair to say that when you asked for that affirmation from your board, that fits into kind of the scope of the thoughts of the board. Fair to say?
I would have expected anyone there to object if they had a different idea about any exceptions or any other ideas about that.
Let me ask you this. Simple question. If the retail space component of this project wasn't part of this project, do you believe that they would have received this incentive?
that's speculative, I can't say, but I think given the circumstances in this case, that was the decisive factor that we used to fund the project.
Okay. Above all other factors.
Above all other.
The word gray box finish out, we've talked about that. We've talked about first floor lease spaces, street level activation. Between the decision day of December 11th, I am kind of moving to a different topic.
Do you know approximately how much more time on this witness?
Well, we have to get through into the 2024, so I do have quite a bit of time, more than a few minutes, that's for sure.
We intend to take lunch at 1, so we'll take a brief 5-minute recess now.
Okay,
Thank
great.
you.
Perfect, thank you.
Okay.
You will. You'll get to eat.
Mr. Flood, are you ready to resume?
Yes. I need to turn her light on. You ready to proceed? Is my mic on? Yes, okay, thank you. May I proceed?
Yes, sir.
Thank you. Ms. Oliveri, we were, before we took our break, we had finished December 11 timeframe. You recall that?
I do.
Okay. The next thing I want to ask you about is the events and the sequence between that December 11 meeting that we talked about a little while ago and that we saw your declaration in, and the next meeting, which was on, I'll represent to you, January 22nd, 2024.
That's
Okay?
correct.
And what, between that meeting in December and January 2024, what would be the things that are going on regarding this incentive in that time frame?
Well, in the December meeting, I just want to clarify so everybody knows that there was a public hearing.
Right.
And that occurred because we didn't talk about that. So there was an open public hearing where anybody can come and state an objection or state a support for it. I think I got one email from the Downtown Management District Executive Director expressing, and that was it. And then from that point on, now we have acted as a board. We then act, because we wait until the public comments, and then there was a motion made, I did a summary, and then we expect that the legal department working with the CCREDC will craft a contract to bring back to us for consideration at the next meeting.
Okay, and I want to represent to you that the tribunal in this case has received certain exhibits, and one of the exhibits is the public hearing that was held on December 11th.
I don't know.
Okay? And I
thank you.
just want you to know
I just
that.
want to make sure.
Sure, sure. And at those public meetings, there is there's Mr. Zanoni is typically there, true?
Yes, I would say most of the time.
Okay. And there's someone there from the legal department that's there, true?
That's true.
All right.
We have to have a lawyer there to constitute the meeting.
And
And someone from the city secretary's office.
Sure. As the tribunal is well aware, there is the eventual product of all of these efforts, should the incentive be approved by the council, is a contract, right?
That's correct. An agreement or contract with the party, the project.
And who signs that contract?
The chair, the board chair. In this case, it was me.
Okay. And who else signs it?
I believe the city secretary attests to it.
Okay. And in that process of between the Type B decision that we went over earlier on December 11th in that public hearing and the contract that is entered eventually, are there certain discussions typically that happen between the applicant and the Type B board? Or a representative of the board, I should say?
Well, I mean, it would not be unusual for me to talk to the legal department, or in this case, to Heather Holbrook, or CCREDC, or even the applicant, just to make sure we've got language that they can live with.
Okay. And the next meeting, the January 22nd meeting, is also a public meeting. There's also a public meeting component of it, correct?
Our meetings are public meetings.
Okay. And in that time frame between December 11th and January 22nd, I will represent to you that there are phone records that have been admitted into this proceeding, which indicate that you had a 23-minute phone call with Philip Ramirez on December 18th, 2023. Okay? I'll represent that to you.
All right.
Do you have any independent recollection today of that phone call?
I really don't.
And this council has heard Mr. Ramirez speak. Would you say that a 23-minute phone call with him is a short one or a long one?
Mr. Ramirez can talk.
All right. Did you have to cut him off? No, I'm just kidding.
I might have.
And so that was a call. And in this time frame, would it have been unusual for you to have a phone call with a representative of the applicant?
No,
And do you even know if that's what you talked about?
I don't.
Okay. But it would make sense that if y'all talked, you'd...
I would think it would be not abnormal after we have voted on the item for me as the chair to speak to the applicant. I don't know, maybe some other board members did as well. I don't know.
Okay. And the records reflect that you also had another call with him on January 10th, 2024, and that one was 14 minutes. Any recollection of that at all?
No specific recollection at all, but again, as these contracts are being developed in the language, it's important to make sure we've got something everybody can live with.
Okay. And so next we're going to go to that January 22nd public hearing. And if you would share with the tribunal, why do you have the second hearing? Why does that happen?
Because we've made a motion on an item that sort of says this is what we want to fund, and had some idea of what specifically we're funding, but the contract has to be, or the agreement has to be developed that will ultimately be signed. So then on that January 22nd meeting, it came back with the actual agreement.
Okay. And I'm going to, you can go ahead and put up Respondents Exhibit 52. And let me show you, this is from the January 22nd meeting. And if you would, can you tell us who's sitting at the table there with you?
A member of the city secretary's office, Mark. I believe that's Mr. Tamez, Mr. Wilson, myself, and Diane.
And if you would, at the table facing, I'm sorry?
And that's Peter and city attorney.
Okay, Peter
Zidoni,
over to the right.
the city manager, sorry.
And at the table in front of you, there is who?
That's Philip Ramirez.
Or are you sure that's Philip Ramirez, or it's not Randy Almaguer?
It could be Randy. It just sort of looks like
Okay.
it might be Philip, but it could be Randy, yes. That's Heather. I can recognize Heather.
And then Heather's there in the kind of the peach sweater there.
Yes.
And so, again, this meeting is part of the purpose of this meeting to discuss the contract itself?
It is.
Okay. And I'm going to play a part of this meeting, and I want you to know that this meeting has also been submitted as as part of the record in this case, okay?
Thank you.
All right.
And by the way, the reason that the board, I believe, agreed that this was a worthwhile project is not because of all the FEMA floodplain zone requirements and everything, but mainly because we saw this as a kind of capstone project in the downtown area to spur other development. I believe we all said we're not interested in fixing everybody's FEMA problem. From now on, you got to include that in your budget or go to the TRZ or whatever. Correct? Okay.
Let me ask you about that. Here we are a month later, actually more than a month later. Last one was December 11th. We're 6 weeks later. And you again publicly state that you're not interested, that the board is not interested in the Type B being a place for general FEMA compliance, right?
That's what I stated.
And if we go back just a little bit there, and the reason I said board is because you actually, you once again asked for your board's, the sense of the, how do you, would you say that? The sense of the board? What do you, how do you?
Giving any board member an opportunity to disagree if I've misstated the summary that I have provided.
Okay, let me play that again.
Now on, you got to include that in your budget or go to the TRZ or whatever. Correct? Okay. So with that,
All right, and so you make that clarification prior to any sort of motion being made to take action. Fair to say?
I don't know the exact sequence, but it was in that same, we either did it right before or we did it after. I mean, it's my job to summarize again, as I read my responsibilities as chair, to summarize what our action would be and what that contract would entail.
And if a person was going to be cynical about this, they may say, oh, well, there you go, see, she's making that clarification again. Why are you making that clarification again?
Because it's very important that we not give the, we did not give anyone the idea that we were going to be available to fund these changes in FEMA or the flood.
Whether they're new, old, any sort of change in FEMA compliance, that was not something this board was going to say as a policy that we will fund.
As I testified, I think I saw that the funding request would be unlimited and that it would be bad precedent. Now, a new board could come in and make another determination, but.
And we'll go ahead and take a look at the actual, the rest of this portion of the meeting, okay?
Entertain a motion to approve $2 million under in the agreement. Up to two.
Yeah, so moved.
Mr. Wilson, that's Mr. Wilson says that, correct?
That's Alan Wilson.
All right. And Mr. Wilson's here in the room today, true?
Yes.
Okay. And Mr. Wilson says up to. Explain to me the import of that.
Well, because if they failed to meet, and I think there's somewhere in this a discussion about the jobs and how many, if they failed to meet the jobs component that was contained in the contract, or if they spent less to build out this space, then we would not fund it except to up to $2 million. So that was a maximum, but it had to be audited, if you will, and meet what we had in the contract.
Okay.
So, yeah.
Up to the agreement, up to two.
Yeah, so moved.
Do I have a second?
Second.
All those in favor say aye. Aye. Anyone opposed, please say no. The motion passes. Is there any comments by Mr.?
So you're about to ask Mr. Zanoni for comments. Why?
Courtesy. Mr. Zanoni or anybody else?
No.
Okay. Can you introduce just, we lost Amy.
So you're about to learn there's a new lawyer that's going to be handling this contract, right?
Right.
Ms. Whitehead?
Right.
All right. And so at the first meeting in December, we didn't, the camera doesn't show Mr. Zanoni, but typically at your meetings, either Mr. Zanoni or somebody from his office is there, fair?
Or Heather is sitting there, yes.
Okay. So someone from city manager's office or the city manager is there and hears the words spoken at the public meetings, correct?
As does the city attorney that's sitting there, as does anybody.
Okay. And let me play the rest of this here.
but we've gained Janet, so maybe introduce her and let us know that.
I'll just introduce her, and then we'll have her introduce herself.
Okay.
But Janet Whitehead is one of our.
Now, a minute ago, you were speculating whether that was
It's
Mr. Ramirez.
it's definitely, yeah.
So who is the gentleman that was sitting at that table?
He's from the CCREDC.
That's Randy Allen?
Ranning.
Okay. And I'm not asking you to speculate based on your experience and your understanding of what, he's there because the EDC is going to be the entity that actually.
Yes, he's very, whoever that is in that position is critical to the process of compliance.
Okay. And also the city legal?
Yes.
Lead city attorneys that's involved in many projects. She's been to many of these type A and B board meetings before for project specifics, but she'll be the representing attorney.
Yes, I am the attorney for engineering services.
Yes.
And so I assist always with specific projects. And so when Amy left, it was just natural that I just moved into type A and B.
And she's been transitioning on some of these agreements, I think, for a few weeks, so.
Yes, ma'am. Yes.
Thank you very much. And by the way, the reason that the board, I believe,
Sorry,
agreed.
I did not mean to restart that. Thank you. I'm done with that exhibit.
I think it is important to note that.
Let me ask you a question.
Okay.
There was something about that you just saw that you want to make a clarification about?
I would like to explain that Amy Alcorn Reed had been our attorney primarily. Sometimes Janet might come in to fill in for her during a pregnancy or something. But yes, there had been a switch over sort of between our December meeting and our January meeting. I can't say which one, whether Amy was primary in the development of the contract with Janet or how that got done. But Amy left at the end of December, I believe.
And there is one issue I want to ask you about, and I should have asked you this early on. And that is when we see those people serving on the Type B board, are they paid for their time on the Type B board?
No, sir, we're all volunteer.
All right. And that is true to this day as far as you know?
I am not being paid to be here, sir.
Okay. You didn't get your $11 with your subpoena?
Oh, well, I haven't cashed the check.
So I want to ask you, at this point, after this meeting, would it be fair to say that the Type B board has adopted a policy in regards to this particular incentive?
I would say that we did not adopt a formal policy, but we did provide, I would hope, some understanding to CCREDC and the community at large as to what we were inclined to fund, at least as the board was constituted at that point.
What some people might call the legislative reason.
That would be a nice term. I wouldn't have used it, but I could see that as a term.
What was the reason for the Type B board's action?
Excuse me 1 second. Just object. That's actually the vote, which is into the minds of others, which would be speculation.
What was the policy that was adopted by the board as a result of this incentive?
We'd object again. She just said they did not adopt a policy.
Well, what is your understanding of what this board's sense, the Type B board's sense was in regards to general FEMA compliance? You've already talked about that.
I summarized it in my statement, and that's why I asked for anybody on the board to object or offer a differing opinion.
Was downtown street level economic revival important to you?
Absolutely.
Was it your sense that that was important to the board?
I think that's what we said, and I think even some of the board members stated that somewhere along in the meeting about it being a catalyst, maybe was the word that was used.
Okay. And let me ask you this question, and there's been a word that this tribunal has heard through other witnesses, and it's the word infrastructure. Okay? Your reaction was, what informed that reaction? Why did you have that reaction?
Well, I mean, infrastructure is more a term of art than a definition. Is it human? Is it walls? Is it, most people might think we're talking about roads or pipes, but it's broader than that. For example, I guess a pier could be infrastructure, or so it's a broad term, differently used by different people.
Does Chapter 505 of the Local Government Code, does it have an infrastructure requirement?
It is one of the sections under which you can decide to fund a project.
Are there provisions under 505 that Type B funds can be used for that do not have an infrastructure component?
Yes, community facilities would be an example.
Okay. How about under the Type B board guidelines that were adopted by the corporation and approved by this council? Do those have a necessary infrastructure component?
It is not absolutely required that there be infrastructure as part of a project.
Okay. So not under Texas law and not under the guidelines?
No, sir.
Okay. If, in this case, the applicant was told that they need to include some sort of infrastructure component in their Type B application, would that have been an accurate thing to state?
I would say it should have been stated in a broader way, from my point of view.
Okay. The building, the hotel that is built, it's a structure, right?
It is a structure.
And it's a building, true?
It is a building.
Okay. So this incentive grant did, in fact, incentivize a structure, or it would assist in the funding of the costs associated with building a structure, correct?
A specific space within that structure, not the structure as a whole.
Thank you. And that being that portion that's on Chaparral, correct?
And Mesquite was the location of the outdoor restaurant is on Mesquite.
Okay.
I think I'm right. I have not ever been to the hotel, so I don't know.
Okay. Now, let me ask you, what we just went over is the January 22nd meeting, correct?
Correct.
All right. Between January 22 and February 20th, and February 20th was the first city council meeting on this item. You understand that? I'm just going to give you that.
I do understand that.
Okay. Tell me about your personal involvement with the materials that were assembled to be submitted to the city council on its first reading on February 20th.
I had no personal involvement. In fact, I did not know the date at which it would be presented. I was not notified.
Okay. Is there anyone on the Type B board whose job it was to interface with whoever it was that was going to be presenting this to the council?
On our board?
Yes.
No.
Okay.
Not that I'm aware of, unless somebody took that on their own. But no, that we did not have anyone assigned to.
You've seen no evidence that there was any member of the Type B Corporation board that was involved between January 22nd and February 20th with assembling the materials that were provided to the council. True?
I see no evidence. I know of nothing that happened.
You wish you had, don't you?
Yes.
Okay, we'll get to that. The staff of the Economic Development Corporation and the staff here at the city are who prepare the council agenda memos typically, correct?
That's my understanding.
Okay. So that would include the city manager?
Or, maybe his delegate, the assistant city manager, legal, along with the CCREDC.
Okay. And as far as what was assembled and presented to the city council on February 20th, before February 20th, did you ever see the presentation that was given to the council?
What was actually given to the council on that date? No, I had seen the presentation that was given to us back in December, but I don't know that I've even seen it to this time.
Okay, so you did receive a presentation by Mr. Ramirez, and this, I'll represent to you, this tribunal has already seen what Mr. Ramirez presented to you in December, okay?
And maybe that's what the council saw, and I don't know.
Right. And Heather Hurlbert, we saw a minute ago, you noticed was at the January 22nd meeting, correct?
If that's the, I thought, is it February 20th?
No. The January
22nd. Yes, I believe she was at our meeting.
I think the
we
peach
saw her.
sweater.
We saw her.
Okay. And of course, we know that Mr. Zanoni was there. You saw that. He actually introduced the new lawyer. Yep. And he said he had no comments. Remember that?
That's what he said.
And you, well, let me show you. I'm gonna show you a couple clips from that meeting. Okay.
All right.
And that February 2024 meeting, you were not there, correct?
I did not know the item was going to be on that agenda.
Let me hold on. Let me get that up here. I don't need it quite yet. The meeting I'll represent to you may look a little odd because it was over at the RTA building. And you referenced that earlier, and hold on. I want to show you a question, and I want you to understand that this video, in a complete, the entire meeting is already admitted as evidence in this case, and so the council, the tribunal has that available to them to watch the entire thing. But I want to ask you about a couple things that happened during that meeting, okay? And again, to orient ourselves, it's February 20th, 2024. The last public meeting of the Type B board was on January 22nd, and you have testified that at that meeting there was the contract. Had you signed the contract already?
No, I don't sign the contract until the council's ordinance they have to pass the ordinance on 2 readings, and then because they could decide to change it, and then normally Ms. Huerta will call me and say the contract's ready for you to sign.
Okay. And after the January 22nd meeting, are you still continuing to work on the contract with legal, or is it pretty much?
I think, for all intents and purposes, it was finalized because at that meeting, the contract should represent what is going to go to the city council.
Right. Okay. So I'm going to go to this meeting, and I'm going to ask you to watch a question that was asked by a member of council. Okay? And let me play this right here. And again, this is from the February 2024 meeting. This is Respondents Exhibit 11, from Respondents Exhibit 11. Isn't that right, Peter? Yes, I think that's right.
Question, and I'm familiar with this. I've had a couple of discussions about it. We're well aware of the disparity between what the EDC had recommended and what the Type B had to do. My concern.
Let me ask you real quick. That the voice that you're hearing is Councilman Hernandez at the February 2024 meeting, correct?
That looked to me like that was.
All right.
My concern is not so much funding this from Type B, but maybe you can speak to the difference or the disparity between the EDC and Type B and why the choice was, one was a recommendation of 1 million, one was 2 million.
I want to ask you, at this point, it's February 20th. You all had your first E-session back in 2023 in November or October?
November.
Right?
Then December.
And then you had your December E-session and then your public meeting.
And December.
Where you announced what you announced that we have seen. Mm-hmm. And then we had the January meeting, public meeting, where you announced what we saw a little while ago. And what I'd like you to do for all of our benefit is that if you had been standing at that podium on February 20th, 2024, and heard Councilman Hernandez's question to explain the disparity between the $1,043,000, which had been recommended out of the EDC, and which was the RIMS model number, correct? All right. If you had been standing at that podium and answered his question, please tell us what your answer would have been.
Well, I didn't make the motion, but I was certainly happy to support the motion made by Mr. Wilson. But I think from my point of view, the REMS model did not include enhanced sales tax revenues that we thought would come in to play off of this retail space, hotel motel taxes, and also just the benefit overall to the community of revitalization of downtown. I mean, some of this is, does it help? Does it incentivize somebody next door to go and revitalize a dilapidated building? And so that street level, that reinvestment, if you will, in an older area can spur on other improvements. And that's generally what it can encourage additional people to live downtown, which I think we've all talked about. And so, yes, I'm a little passionate about that.
Okay. So had you been there and you had the opportunity to answer that question instead of Ms. Hurlburt, is that?
I would say that was for me more than just jobs.
Okay. It included downtown economic revitalization?
Yes.
A blighted area?
Yes.
The jobs?
That was the 1.423 or whatever number.
Right. The street level activation?
Yes, that's the people coming and going, moving around.
Right. Let me show you the answer that the council received that day, February 20th, to that question. Okay?
Okay.
The Heather Hurlburt, Assistant City Manager. So the EDC came back with a recommendation of a little over $1 million, but after the developer spoke with the Type B board, they went ahead and went with the $2 million, which was the original request.
Let me stop you right there. Stop it right there, sorry. She said that after the Type B board met with the developer, they went with the $2 million.
I don't think that's really an accurate statement. I don't know who, she said after they met. I don't know who we met with, but.
Okay?
I mean, maybe some of the other board members had met and discussed the project. All I'm telling you is I had that one less than a half an hour discussion, and it was not in detail.
Well, they were.
They did presentations.
They did a
too.
presentation.
Yeah, but I mean, I'm not saying that other people did not. I don't know that.
And what the council heard or saw during Ms. Hurlbert's deposition, during Ms. Hurlbert's statement is what we see up on the screen there, which is the infamous altered slide. See that there?
Yes, I see it.
All right. That, what the council's looking at right now and what the council looked at on February 20th, that information, did it reflect the decision of the Type B board?
No, nor did it reflect the contract.
I'll continue with her answer, although the slide, for whatever reason, remains up.
Can you give some more detail besides that?
She says, she speaks temporally. They made a presentation and y'all went with 2 million without any sort of reasoning, right? That's what we've heard so far.
Mm-hmm.
Is that a yes?
I believe that's what she said, yes. Sir.
Yes, and the only reason I said yes is for that court report
Yes.
over there. Thank you.
That is what she said.
I didn't mean to be rude in that.
That is what she said.
All right.
Besides the fact that that's what the board went with, I mean, there was discussion on what the 1 million versus the 2 million would do. It was expressed by the developer that they really were holding with the $2 million request, and that they would need that to do the type of flood mitigation.
Now, you just heard her response, okay? Did her answer reflect what the Type B board's decision was?
Again, I will point you back to what was said by me as a summary of what we did, and I do not believe what she said was incongruent with what we said in summary, or I said in summary.
Thank you, thank you.
Okay. Her answer was not accurate, was it?
Check to the form of the question, you mean for her, for this witness?
Was her answer accurate?
To me, that was not an accurate answer.
Okay. The more accurate answer would have been what you shared with us earlier when you answered Councilman Hernandez's question directly a little while ago. Fair to say?
The more accurate answer would have been for exactly what we approved. It would have been for street level activation, for retail, and then we could talk about the benefits of that as opposed to just the construction and jobs.
And so a change in maps narrative, okay? When I say that, you understand what I'm referring to? All right. If a change in maps narrative was then restated by council members, would that have been a discussion of the actual reasons given by this board for the incentive?
Well, maybe I'm getting a little tired. Maybe you need to parse that down for me again. Can you start again?
Sure. I'll give you an example. Councilman Pusley, and this is as part of the record, both the transcript and the hearing. Not every hotel is going to have to be built in a flood zone where they have to elevate the hotel 4 feet in the air. That's sort of special circumstances that we wouldn't ordinarily look at on some projects. So we've got to be really careful about saying, you know, this is a block-in standard we're going to follow in every case. Earlier, we were talking about general FEMA compliance. Remember that?
I do remember that.
Does that statement by Councilman Pusley seem to suggest that the conversation may have been about general FEMA compliance?
It would seem like to me maybe he was thinking about that as general. No, that it was the flood wall and floodplain issue.
Right. And so the February 20, 2024 agenda memo, okay, for this item, and you understand when I say an agenda memo.
I know what that agenda amendment is.
If it simply had the same presentation that was given to the EDC, would that have been an agenda and an agenda memo that presented the council with the actual reasons that the Type B board recommended the incentive?
So I would have expected personally, and I think it would be correct, that the agenda memo should have represented what the actions of our board was, if it wanted to talk about what the original request was or the history of it, that would be okay. But it was simply, as I saw it, much the same statement that it all started out at. Whether they wanted to include the applicant's original presentation to us, that's fine. But, I mean, and they may have wanted to do their own PowerPoint edition. This is what the contract actually says.
Well, a minute ago, I showed you the screen, the slide that they, and you and I had a discussion about that.
Right.
And that actual slide and the information included on it was not a reflection of what the Type B board's decision was, right?
Again, that council memo and that slide seemed like it went back to the very beginning to me and not reflective of the actions and the reasoning that we took to fund this project. Or at least as I summarized what we took.
Yeah. So the application to the EDC contains that slide, and it contains this narrative of, hey, we need this money for FEMA compliance because there's this change in the FEMA maps. That reasoning and narrative and slide makes its way into the EDC, correct? As far as you can tell?
Into the agenda item? Is that what you're saying?
No, I'm asking, I'm going way back in 2023.
Yes, yes.
And then it's part of the presentation that's actually given to you at the Type B board, right?
It was given to us.
Yes. And then the Type B board makes its decision for different reasons than those that were given to the EDC and presented to you by the applicant, correct?
As I summarized, yes, we determined that was not what we were doing. We wanted to fund this other thing.
And so that narrative and slide, altered slide, come this way, and you say, stop, here's the real reason. But when it comes to the council, staff simply picks that up and presents not the Type B board's reason, but a presentation that was given to the Type B board, right?
And a memorandum reflecting that same thing.
And so the discussion.
Excuse me. I'm so sorry, Mr. Flood. Is this a good?
Oh, I'm sorry.
Is this a good time to break for an hour?
Sure, that's fine.
All right, then we'll reconvene at 2 p.m. Thank you.